corporate debtor as a going concern. So we will first try to understand the legal provisions, and then I'll run you through the various precedents which we have in terms of approvals of sale as a going concern, and what procedures are being followed in NCLT Mumbai or NCLT Hyderabad, like various NCLTs, how they are approaching sale as a going concern. We will have a fair idea of that, and also some practical nuances when it comes to sale as a going concern based on my prior experience or working of the sale as a going concern. I'll try to bring it to the knowledge of all of you. It will be on two fronts. One from the point of view of the liquidator, and number two from the point of view of the successful bidder. So this is precisely what we will try to capture during our session on sale as a going concern. So as I said, first and foremost, we will try to understand the legal framework involved with sale as a going concern. So before that, if I have to give a brief background of how this has evolved as a manner of sale under IBC, is that earlier we had only four different ways in which we can sell assets under liquidation. One is selling it as on a standalone basis. Second, on a slump sale. Third, on assets collectively, and fourth, assets in parcels. But after understanding that, with limited time, like in the CIRP, the companies are being pushed into liquidation. So it is, it is then the IBBA has then allowed this additional manner of sale, which is manner of sale by way of sale of corporate debtor as a going concern, as well as sale of the business of the CD as a going concern. So these are the two different sales which are allowed under the liquidation regulations. Now, what is the difference between the two? One is sale of the CD as a going concern, and the other is sale of the business of the CD as a going concern. So when we do the sale of business as a going concern, the entire business, that is, the operations of the company are being transferred, right? It's not the company per se. So what does it mean? It means that we are, it means that only the business of the CD is being transferred from one entity to the other, while the company continues as is, right? So that is the major difference when it comes to business, selling of business itself as a going concern. So when we talk about only the part of business of the CD as a going concern, what we need to understand is, let's say there is a company which is undergoing the process, right? Let's say there's a company which is undergoing the liquidation process, and it has got three business verticals, right? A is into one vertical, B is another vertical, and C is another vertical. Now, if the liquidator is focusing to sell only one business vertical, it is called as sale of business of the CD as a going concern. Or it may so happen that it may so happen that you may not have, any other business verticals. Okay, let us also try to capture that particular scenario. Let's say there is no business vertical B or C. The company only has one business vertical, but you are, instead of transferring the entire company, you are only transferring that particular business vertical, right? Including the business assets, liabilities, only, or business and assets only of one particular business, or only the business per se, but the corporate shell is still being retained under the liquidation process and will be taken forward for dissolution. So this is one aspect of it, which is sale of business of the CD as a going concern. Now, in the same example, if instead of transferring the business, if we transfer the entire corporate debtor as a whole, that is what is sale of corporate debtor as a going concern. So today we will precisely discuss on the topic E, which is corporate debtor as a going concern, right? That is more interesting and more complicated than sale of business as a going concern. But one major hiccup when we talk about sale of business of the CD as a going concern is the stamp duty, which you don't have when you take the when you acquire the corporate debtor as a whole as a going concern. So when you're only transferring the business as a going concern, it will tantamount to, if you want to affect, like there are two ways of looking at it. One is the sales certificate given by the liquidator. If the auditor and also as a matter of legality, the bidder is okay with that certificate as the finality, then the certificate alone should be sufficient for evidencing the transfer of business. Otherwise, generally, any business transfer for the purposes of income tax, etc., it will be treated also uh, as an actual acquisition of a particular asset. And also for the purposes of registering that sales certificate, it will amount to a business transfer agreement. So such kind of documentation might be required, and additional stamp duty might also be involved if you're talking as, so if you're looking for sale of business as a going concern. But now when we talk about sale of CD as a going concern, it is as good as a resolution plan. So generally in a resolution plan, how a successful bidder acquires the assets completely as a whole and continues the CD going forward as a going concern. Similar situation we see during liquidation when we are selling the complete corporate debtor as a going concern. But it is extremely important for us to appreciate how this going concern thing will be reflected, right? So we will just try to make some parallels between a resolution plan and a going concern, and then probably we will try to bring probably then we will try to go much deeper into the subject on going concern. Just a second. Yeah. So on the left hand side, let us try to look at see resolution plan, and on the right let us look at CD as going concern sale of CD as going concern under liquidation process. Now, what is the major parallel we can draw between the two is that in case of a resolution plan, as well as in case of sale of CD as a going concern, there is absolute change of control. So the control from the existing management gets transferred to whosoever be the either successful resolution applicant in the case of resolution plan, or a highest bidder or a successful bidder in the case of sale of CD as a going concern. But when we talk about the other aspects of the procedure, see, when you look at the procedure, in case of a resolution plan, there are certain mandatory contents of the plan given under section 30 subsection 2, as well as CIRP regulations, which prescribe as to various situations like how do you, first there is a procedure involved, like we invite resolution, expression of interest, then an expression of interest is submitted, then we give them a request for resolution plan, we give them as to how they will be treating the available cash in the company, or even the meeting of the CIRP cost, blah, blah. Everything is clearly laid out for a resolution plan. And then a document which encompasses all that will be submitted to the resolution professional. It will be put forward before the COC, and that which is approved by the COC will be placed before the NCLT for the final approval. Now, this is typically the procedure for approval of a resolution plan, right? But when it comes to sale of CD as a going concern, there is no such formalized procedure which we have. Only thing we do is we do an auction, correct? And in the auction, whosoever is the highest bidder, that highest bidder will bring in the money, and then we will be transferring the asset to the highest bidder. Now, this is a typical simpliciter procedure which is followed when there is a sale of CD as a going concern. Now, what is the challenge? Is it a problem doing this? No, there is no problem as such doing this, but the concerns, there are certain concerns which involve when we do a sale of CD as a going concern. Now, what are those concerns? Now, as in the
Can I
resolution,
interrupt here if you don't mind?
yeah. Sorry, go ahead, sir.
Yeah. So, your point is well taken. But what is the difference between this sale of asset as a sale of this CD as a going
Business.
concern and slump sale then?
Yeah. So in sale of CD as a going concern, we are giving the entire company. But whereas in a slump sale, only the assets are transferred. The company is still under liquidation. The company will still be dissolved. Whereas in a sale of CD as a going concern, the company will not be dissolved. There will be a closure of the liquidation process. The company is being transferred and continued by the successful bidder in the same name of the company. Whereas in a slump sale, you are only collating some assets as a single lot and selling all the assets as a slump sale. Only the transfer of assets, transfer of title over the assets. So basically, you're stripping off the assets from the company, but the company is still in existence and the liquidator will take the company into liquidation and for dissolution. Whereas in a sale of CD as a going concern, along with slump sale, like you can say it might also be a slump sale because all the assets are being transferred. Along with all the assets being transferred, even the CD is also being transferred, which means the company is still under existence. It will not get dissolved. That's why when it is a slump sale or any other manner of sale, collective sale or even standalone sale, we file for dissolution of the corporate debtor. But when it is sale of corporate debtor as a going concern, we file for closure of the liquidation process. So there is a different regulation given for closure of a liquidation process. So that regulation will come into force whenever we are talking about sale of CD as a going concern. I'll just quickly show the regulation on screen.
So how? So as far as the these MCA records are concerned, they will, when it goes from resolution to liquidation, they will change the status to under liquidation, right?
Correct, correct.
So then you will file another form for restoration of the CD as a going concern, correct?
Correct, correct. So
Okay.
how it happens, sir? So I think since you raised it here, I thought I'll discuss at a later time. But anyways, we'll discuss right away. So if you see this point, sir, under Regulation 45, final report prior to dissolution, it clearly says after completion of the process, along with final report and complaint certificate, we will file for closure of the liquidation where the CD is sold as a going concern or a compromise or arrangement has been sanctioned. Because in both these situations, the company continues in existence. That's why we file for closure of the process. Whereas for any other situation, we file for dissolution of the corporate debtor. Now, when we file for dissolution of the corporate debtor, obviously the company is wound up without being, it gets dissolved and wound up. So it is accordingly recorded in the MCA. But if we are only doing a closure of the process and the company is continued, in that case, what happens is upon filing of the closure of the liquidation process, IBBA will communicate to the MCA to change the status of the company from under liquidation to active. So that procedure we have to follow with IBBA, follow with MCA, and get that changed on the MCA portal. But we have faced in a similar in a case where we are currently assisting a bidder, successful bidder in taking in the transition phase. We are following up with IBBA. There, the liquidator is yet to file a closure of liquidation process application, because of which MCA is not changing the status from under liquidation to active. Now, until and unless they change that, subsequent forms, etc., cannot be filed by the successful bidder. So that threat is there. So, anyways, that's the procedural aspect of it, sir. But
yeah, very good, sir. Yeah. I think you answered my question.
Yeah, thank you. Okay. Okay. Now, as we move forward, now that so coming back to this one major issue, which is in a sale of CD as a going concern, the successful bidder does not submit any document which contains as to who will be the proposed directors, who will be the shareholders, what will be the treatment of the funds infused into the company, what happens to the existing capital of the company. None of this is answered by the successful bidder before the sale of CD as a going concern. Whereas in the resolution plan, all of this will be recorded in a resolution plan, which is also placed before the NCLT. And once NCLT approves, there will be an extinguishment of capital, change of directors, removal of the existing directors, and also change of the shareholding, infusion of shareholding, any other corporate restructuring which they want to include as allowed under Regulation 37 of CRP regulations. All of it they can propose under a resolution plan for a proper takeover. But when it comes to sale of CD as a going concern, there is some challenge which we will try to understand during our session today. So that will be my major focus, and I'll also try to share some orders which can give us some idea on how NCLTs are looking at sale of CD as a going concern, and as liquidators, what will be our role there is something which we will have to carefully analyze. So now let us take this step forward to see under regulations this process of sale of CD as a going concern is being taken care. Now, first and foremost, sale of CD as a going concern is also it will come under the manner of sale. Okay, under Regulation 32, one of the manner of sales is sale of corporate debtor as a going concern. Now, for that, as an extension of that is given under Regulation 32A. Now, under Regulation 32A, it provides for two situations. One, a situation where the COC would have recommended, right? That is nothing but whenever we put a plan for voting or when the COC is considering liquidation, it is mandated under Regulation 39 of CARP regulations that the COC shall opine whether this company, if at all, if a liquidation order is passed by NCLT, should the liquidator explore the possibility of sale as a going concern is something which the committee of creditors. No, this is not SCC. This is the committee of creditors I'm talking about under CARP. They should recommend it. Now, this recommendation comes under the CARP regulations and not liquidation regulations. So whenever under CARP also, as a resolution professional, whenever the resolution plan is put to vote, we also have to put to vote this particular agenda, stating that in an event the NCLT orders for liquidation, then the committee, whether the committee recommends for sale of this company as a going concern or under any other manner of sale. This is something which we have to adequately record in the minutes of the committee of creditors. Now, once the committee of creditors have recommended this, or now see, there is also an inherent responsibility and some level of authority given to the liquidator to opine if the sale of CD as a going concern maximizes the value of the CD. Right? Now, for example, the committee of creditors do not recommend, let us say, okay, for the sake of it, let's say, for the sake of argument, let's say the committee of creditors do not recommend it. Still, as a liquidator, if we are of the opinion that the sale of CD as a going concern can maximize the value of the company, then we can definitely do that. But what is important to highlight here is the text which you can see on the screen, which is he shall endeavor to first sell under the said clauses. Now, this is something interesting. So, what it says is, if at all you are of the opinion that this can maximize the value, then you should endeavor to first sell under the said clauses, that is E or F. Meaning, if you really think this company as a going concern or business as a going concern is meaningful, then you should first explore that. Only if it fails, then you can come for the rest. Or the other meaning which we can see from here is, for example, initially, let's say you went ahead for selling the CD on a standalone basis. You divided all the lots. Now, after the auction went for thrice, 3 times it failed, then you want to go for sale of the CD as a going concern. Is that allowed? Technically, as per the regulation, that's not how it has to be. Because as per the regulation, this decision on selling the CD as a going concern should happen at the first instance of when you go for the sale of the corporate debtor. So first endeavor has to be made. If at all you have an opinion that the value of the CD will be maximized if you opt for sale of business or corporate debtor as going concern, then the first sale which you propose should be under the going concern sale. So the first auction which you propose will be also under the going concern sale. Right. So that's why even when you see auctions coming out from liquidators, whenever there is a going concern sale, it will be usually in the first auction which the liquidator comes out after the company goes into liquidation. But if you say so, like for example, couple of times we tried and the entire process failed, but suddenly some investor had shown interest for buying the entire company as a going concern. Is that allowed? It's not technically allowed as such as a liquidator's right. It's allowed subject to NCLT's approval. So in such a situation, it is always preferred to first file an application with NCLT stating that we tried to do a going, we tried the standalone and other sales, they failed, but now we have a serious interest for selling this as a going concern. We want to explore it, kindly allow us to do so. So that will be an ideal approach. Anyways, now as we move forward, if we are looking for sale of CD as a going concern, then sub-regulation 2 mandates that we need to group the assets. Now again, it says as identified by the COC under regulation 39C. Now, which means thus during the CARP itself as an RP, we have certain responsibility to group the assets and liabilities of the corporate debtor. Now, this is something not many actually do. But of course, if we see that the company is pushed into liquidation, I think as RP, we have to ensure that at least these assets and liabilities of the CD are adequately grouped, particularly when we are exploring for sale of business as a going concern instead of sale of CD as a going. Because if it is sale of CD as a going concern, anyways, all assets are being transferred. But if it is only one business you are trying to go for as a going concern, then the assets of that particular business should be adequately grouped and there should be separate books maintained so that when we transfer that business at a later stage, we can easily do that by way of having a separate books of account being handed over to that particular successful bidder. So that is sub-regulation 2. And then where, if in an event where COC has not identified it, then the liquidator should identify it in consultation with the SEC, which is fine, and then the liquidator may sell the assets exclusively only at the first auction. Now, again, this is one more important point to be noted. So it says the liquidator may sell the assets of the CD under clause E. Now, clause E is sale of CD as a going concern, right? CD as a going concern. Now, you can do that exclusively only at the first auction. Okay, which means if you want to not sell any of the assets on a standalone basis, you want to only explore sale of CD as a going concern alone, then you can do that exclusive sale of CD as a going concern only in your first auction. Now, what does this mean? This means if you fail to have the auction, if the auction fails after the first auction, then from the subsequent auction, you should mandatorily also provide other options of sale. Like for example, in the first auction, sale as CD as a going concern failed. In the second auction, you may still keep sale of CD as a going concern as option 1, or you should also provide other options wherein some assets are also being sold as a going concern on a standalone basis or as a sum sale basis or collectively, whatever is it, right? So that's why the explanation also clarifies that position, wherein it says the sale of the CD under 32E cannot be offered as the only option for bidders after the first auction. So once the first auction fails, then after the first auction, for all subsequent auction, option 1 can be sale of CD as a going concern, but option 2 should be, you should also list down the assets for sale in all other manners as well. So therefore, that is also extremely important to ensure, because you cannot keep on trying for sale of CD as a going concern for multiple auctions. That is what is the intention behind this regulation. Yeah. Next, if at all during the CAR, during the liquidation process, there is a viability to run the corporate debtor as a going concern. In such a case, the liquidator should first consult with the SEC. Next, only if the SEC gives its advice to run the company as a going concern, the liquidator can do so. So this is also important that liquidator will be able to run the affairs of the CD as a going concern only and solely if the SEC gives them the advice to take it. So generally, when a company is a going concern is brought into liquidation for whatever be the reasons, then during liquidation, liquidator should not assume that because I have sufficient cash flows, I will go ahead and run the CD on my own. So initially, in the first meeting, which has to be held within 7 days, the liquidator should take immediate approval and advice from the committee that this process, we can continue to run the company as a going concern. So that this is all about the theoretical part on sale of CD as a going concern. Now let us come back to our discussion on understanding how we can affect this sale of CD as a going concern. Sorry. Yeah. So now let's first understand that the step 1 when it comes to sale of CD as a going concern. The step 1 is public auction. Now, what do we do in a public auction? So in a public auction, we are basically prescribing a reserve price and inviting all the
interested parties to come bid for the particular asset. Now, when the bidders are bidding for the particular asset, what we need to understand is they are looking for the entire company being acquired by them. But the only platform we are giving them is an auction platform, wherein, of course, we will give them a VDR, we will give them all the required documentation, everything for them to take a decision to acquire the entire company. But ultimately, what they're doing is bidding for the company. That's all. They are not doing a negotiation with you. They might do, but ultimately, it will boil down to a transparent bidding process on the BankNet portal. So today, as you all know, we are all following the auction norms only as per the BankNet. And under BankNet, whatever auctions we are pursuing in that, the entire auction process per se has been automated under BankNet. So all the required documentation for eligibility, etc., will be submitted directly on BankNet. And till the completion of auction, you will never know who are all the actual participants in the bid. So this way, they have kept several checks and balances to ensure that the bid is not being managed from the liquidator's end, at least. So there is good amount of integrity which they are trying to maintain in the process by providing some strict norms as regards the liquidation process, particularly the auction process. So in the step 1 in the public auction, all interested bidders are actually bidding for a particular asset, which is in this case CD as a going concern. Now in the public auction, after the completion of the public auction, the step 2 in the process. The step 2 in the process is that of declaration of successful bidder. So the step 2 of the process is declaring the successful bidder. Now, how do we declare the successful bidder? So whosoever bidder has got highest bid, we will place it before the committee, and we will first analyze the eligibility of that bidder. Then we will inform the SEC that this guy is the ultimate bidder. Now, subsequent to that, the SEC will say, okay, fine, we are okay with this guy to be declared as a successful bidder. And in consultation and after approval from the SEC, we will be declaring that particular highest bidder as the successful bidder. So this is step 2. Now the successful bidder is declared. Step 3 is, Now, step 3 is after the successful bidder is being declared, then there is a deposit of sale consideration. Now, this is extremely important because unlike resolution plan, there will not be any deferred payments allowed in a sale of CD as a going concern. So, entire amount has to be paid upfront, not exceeding 90 days. And if it has to exceed 90 days, then SEC should have given its approval. And any amounts paid after 30 days will attract interest at the rate of 12% per annum. Now, these are standard norms for a sale of assets under public auction. So, where we are looking for sale of the, sale consideration. So the third part is receipt of sale consideration. Now, once sale consideration comes, the next step is.
Sir, if I may just interrupt here.
Yeah.
So before the sale is announced, you will have a reserve price to be set, right?
That's before even going for an auction, correct?
Yeah. So what is the basis of the reserve price?
Sure, sir. I'll explain that. So, as asked by sir, firstly, the reserve price, who sets the reserve price is also something which we need to see. Under Regulation 31A, it says the committee, the stakeholders consultation committee has been given this authority to advise on setting of the reserve price. So, if you see, the liquidator shall constitute committee to advise him on matters relating to, right, which includes sale under Regulation 32, including manner of sale, pre-bid qualifications, reserve price, marketing strategy, and auction process. So first step is the SEC should be in a position to advise the liquidator on the matters which pertain to all of this. So even the manner of sale, that is sale of CD as a going concern, let the SEC also advise on it. Then pre-bid qualifications if you want. If you really want only serious players to participate, then go ahead. You can try to fix that also. Then reserve price. You can also come forward with reserve price being fixed, in this entire thing, the reserve price also might be advised by the committee. Now, but now, what is the basis on which reserve price is fixed is what sir had rightly asked. So the basis for fixation of reserve price is on the liquidation values which are given under regulation 35. Now, which schedule or what exactly under which regulation talks about it is schedule 1. So for any auction related things, we need to head to schedule 1 of the liquidation regulations, which provides for the mode of sale, and also in the auction it provides for mode of auction, a mode of sale, in which it also provides for under the public auction how do we initiate the auction, and everything is very clearly provided, including the timelines, right? So 35 days timeline or whatever with what we see with respect to public auction is something which we derive from schedule 1 only. Now in this, when it comes to fixing the reserve price, clause 4 of schedule 1 is something which we have to run through. So it says the reserve price shall be the value arrived at in accordance with regulation 35. Now this is the first thing which we need to see. Okay. Now, once again, sorry. Yeah. So first and foremost, it is as per the value arrived at in accordance with regulation 35, and regulation 35 is nothing but valuation provided by a registered valuer. So that is point number 1. Now, point number 2 is if that auction fails, then can you reduce the reserve price is something which the other part of clause 4 talks about. It says if the auction fails, reserve price in subsequent auction can be further reduced by not more than 10% at a time. Now, this is a general rule. General rule is from the previous auction's reserve price, at the most 10% is what we can reduce. But is there an exception? Yes. The exception is provided under proviso. The proviso says, in cases where the reserve price of the failed auction was fixed as per valuation, the liquidator may, on the advice of the committee, reduce the reserve price up to 25% once during the process. So if you can still go ahead and reduce, but only once. Now, by not exceeding 25% of the reserve price. But this is only in a situation where the valuation is fixed as per 35(1). Now, what is this regulation 35? Let's have a very quick look into regulation 35. Regulation 35, as I said, is the valuation point, right? So this is valuation of assets intended to be sold. Now, 35(1) is when you are relying on values under CIRP. So where you are relying on values ascertained by the valuer under the CIRP process, then you can reduce the reserve price by not exceeding 25% at least once. I mean, not more than once in the process. But if it is under any other, you are relying on the value under as per regulation 35(2), that is where you have taken a fresh valuation, right? Under the liquidation process, then you cannot exceed the, you cannot reduce the valuation by more than, reserve price by more than 10%. Now, this is what is regulation 35. So 35 as sub-regulation 1 says that a liquidator can rely on the valuation conducted during the CIRP process, that is corporate insolvency resolution process. Then liquidator can simply consider the average of the estimates of the values arrived at during the under the CIRP by for the purpose of valuation. But in an event where the liquidator, in consultation with the SEC, is of the opinion that fresh valuation is required. So earlier, before this amendment was introduced only in 2024 February, wherein before 2022 February, the language is where the liquidator is of the opinion, right? If you see, it simply says where the liquidator is of the opinion. But now that is being substituted, saying where the liquidator, after consultation with the SEC, is of the opinion. So though the liquidator will take that call, but he has to first consult the SEC prior before taking this call for fresh valuation, right? So that's when he has to, after consultation with the SEC, should opt for a fresh valuation. And when he appoints 2 registered valuers, they'll have to give valuation under A to F of 32. That is, for each manner of sale, a valuation, a realizable value has to be provided by the liquidator. I mean, a realizable value has to be provided by the valuer. So if you are relying on valuation under CIRP, then the average of the values total aggregate of the average of SFA, plant and machinery, and building and land and building together will be what will be your basis for reserve price of sale of CD as a going concern. But if you are going for a fresh valuation, then the valuer will indicate the realizable value for sale of CD as a going concern, right? So this is all about the fixing of reserve price, sir. Hope it is clear, sir. Anishji? Okay. Yeah. So as I was discussing, there are 4 steps involved. Yeah. Thank you. There are 4 steps involved in whenever we are doing a public auction. First is actually going ahead with an auction itself, then declaring a successful bidder, then receiving the sale consideration, then issuing the sale certificate. Now, this is from our point of view. So from the liquidator's point of view, the moment I issued a sale certificate, the company is completely handed over. So I will also hand over the control of the company operations and the entire, along with the sale certificate, to the successful bidder. So there is a physical position transferred. Constructive position is also transferred on all the assets and business of the company. This is clear. So sale certificate plays a very crucial role when it comes to transfer of CD as a going concern. But what are the challenges involved? Let us try to focus more on that during the session. First challenge, which in my opinion is that when I take the CD as a going concern, what exactly am I looking for in that particular sale is that, let's say, I have my own board of directors, correct? Let's first start the discussion on board of directors. Now, CD has got its own set of directors. Let us assume there are 2 directors on board, okay? Mr. C and Mr. D. Let's say the company has got 2 directors, Mr. C and Mr. D. Now, the company has been sold as a going concern, correct? So when we are declaring that the company is sold as a going concern, what exactly do we mean? This entire CD per se, right? This entire corporate debtor per se has been transferred to successful bidder. Okay, which means technically the successful bidder has got 100% control. Right? So successful bidder has got 100% control over the CD. But as per the Companies Act or as per any corporate law provisions, control can be acquired through 2 important things. One is shareholding. The other is directorship. Now, when you are issuing the sale certificate, okay, so when this sale certificate has been issued, the CD, in this case, neither the directors of the CD change, nor the shareholding of the CD will change. I'm talking about just the issuance of sale certificate. So the sale certificate will not have the effect of changing the directors or changing the shareholding, but it does transfer the control. Now, how is it being achieved? How can we achieve this? This is actually a practical issue we face whenever we do a sale of CD as a going concern. If the same situation does not come in resolution plan, because resolution plan clearly provides for change of directors, clearly provides for change of shareholding, and NCLT approves it. Therefore, the NCLT order itself acts as all the essential necessary change of control things are being provided under the NCLT order itself. So there is not a challenge. But since a liquidator does not have the powers of an NCLT, the sale certificate do not actually, any sale certificate you take of any liquidator will not give such things like the shareholding is changed or directors are changed. It might only, as regards directors, there is something we can do as liquidators, but as regards shareholders, there is nothing we can do, right? So first let's stick to the directorship thing. How do we change these directors? First and foremost, the Ministry of Corporate Affairs has allowed or is allowing liquidators to file for change of directors. So there is a form DIR 12, and this going concern process memorandum, if it clearly contains all these clauses on change of control, etc., along with that, a detailed note by the liquidator explaining the ROC as to why there is a change of directors, all of that can be clearly laid on, and the liquidator can affix the DSC for change of directors of the corporate debtor. The liquidator can certify the addition of the directors by, as proposed by the successful bidder. That is, the new directors nominated by the successful bidder can be appointed by filing DAR 12. In the same DAR 12, we can also include removal of the existing directors by virtue of operation of law. Right? Because as per the liquidation regulations, they cease to they discharge the position as directors. That is also there. And as per the sale of CD as a going concern, the new successful bidder is taking over the control over the CD. Therefore, when it comes to the change of control of the board of directors, yes, as liquidators, we should and we can assist the successful bidder in changing the directors. So to that effect, we can do through filing of DAR 12. Of course, it's not a straight through process form. It is a form subject to approval of the ROC. But with some liaising with the ROC, we will be in a position to get this form approved. And we did that in multiple occasions. So I'm talking out of experience and not just the theory part. So this is with respect to appointing directors. Now coming to shareholders. Now see, when it comes to shareholders, there are two layers. One, the existing shareholders should be removed. Right? So there is a need for extinguishing the existing share capital of the company. Two, there is a need for infusion of additional capital, or rather allotment of equity shares in favor of the successful bidder. Now, these are the two important things which we have to achieve, essentially achieve when we are discussing on sale of CD as a going concern. So when we have to get new shareholders on board, we need to do an allotment. Now, how do I do an allotment as a liquidator? Right? So that is a problem. But how else can we do? Yes, we still can do an allotment, because now that the liquidator has appointed new directors, the new directors can convene a board meeting and do an allotment of shares. This is possible. But general tendency and also general expectations from the legal fraternity and also from the successful bidders, so the legal counsel of successful bidders, is that these kind of allotments or change of control should either happen through the liquidator or through the NCLT. They are generally not comfortable if the directors themselves are taking any decisions with respect to allotments, because even though they are directors nominated by the successful bidder, they do not want to take such decisions which might cause some issue on legality at a later point in time. Therefore, they will generally require the stamp of the NCLT to get that done. That is first point with respect to allotment of shares in the favor of successful bidder. Second point is with respect to extinguishment of the other existing capital of the company. Now, why is it important? It is important because if you don't do that, ultimately the control will still be with the existing shareholders of the company. Now, how do you achieve it? Can the liquidator cancel the existing shares? Or can the successful bidders or the directors nominated by the successful bidder, can they on their own change the existing shares or reduce the existing shares? The answer is no. The only authority which has the only body which has the authority to affect the reduction of share capital is the Honorable NCLT. So therefore, a requisite application has to be filed with the Honorable NCLT for removal of the or for reduction of the existing share capital of the company. So that is an extremely important step which has to be achieved. So existing share capital has to be reduced. So which means you will 100% need approval from the Honorable NCLT. So now I will take a pause here and run you through a NCLT order wherein this exact kind of sale of CD as a going concern has been approved by the Honorable NCLT. So we will look at that order. It's an order in July 2024. Just a second. in Bharati Defense, this was a company sold as a going concern. Okay. This has come on 29th April 2024. I'll just see. This is the IA. Now, who filed the IA? The IA was filed by the liquidator. Okay. Just like how in a CIRP, the IA is being filed by RP. Here in this case, the IA is being filed by the liquidator, right? Just a second. Sorry. I'm sorry. Yeah. So the IA has been filed by the liquidator. Now I'll just pause here just to take some reference from this. Again, different NCLTs are approaching this differently, actually. Now, this is NCLT Mumbai, where they allowed the application to be filed by the liquidator himself. Okay. Now, I know a case in NCLT Mumbai only, a different bench, where they didn't entertain the petition filed by the liquidator. So they said the company is sold as a going concern already. So any relief should be sought directly by the successful bidder. Now, that was one of an order. It was not like a precedent, but majorly it is the liquidator who is filing these kind of applications, just like a resolution professional before the NCLT. Okay. So similarly, a liquidator is filing this particular application for sale of the CD as a going concern. So what is the prayer they asked? If you see the prayer they asked, the first prayer is approval of sale of the CD as a whole on a going concern basis. Right? So approval of sale of the CD as a whole on a going concern basis, along with certain reliefs. That is point number B. Grant of certain reliefs and concessions in favor of the successful bidder, and approval of treatment of certain assets and litigations excluded from the sale. So now what is important for us is A and B. Approval of sale of the CD as a whole as a going concern, and grant of certain reliefs and concessions. Now, the point to be answered by all of us is, we have seen the entire theory in terms of the sale of the CD as a going concern. Nowhere does it mention the need for a prior approval or a post approval from the NCLT. So in all respects, in my view, there is no necessity to obtain the approval from the NCLT for sale of the CD as a whole until and unless it is a private sale. If I am able to sell the corporate debtor as a whole under by way of a public auction, I need not approach the NCLT for its approval, because I have already done a public auction, and in the public auction, a successful bidder has evolved by a bidder has evolved as successful bidder for acquiring the entire CD as a whole. So therefore, I don't need to go to NCLT for the approval. Only thing I need to go for the NCLT will be grant of reliefs, right? So therefore, only application for which we will approach NCLT in the case of sale of CD as a going concern will be for the sake of grant of certain reliefs and concessions, right? Now, yeah. What are the reliefs and concessions asked for? Let's look at that. First, all liabilities, whether crystallized, not crystallized, etc., shall be deemed to be extinguished. Now, this is a standard thing which we have in resolution plan. And yes, the NCLT had allowed it on a clean slate principle because it's a sale of CD as a going concern. Now, it shall be binding on everybody. Yes. Then benefit of section 32A. Now, this is again an interesting thing which we need to discuss. Now, section 32A, when we look at the code also, it is very clear. It is not just limited to approval of a resolution plan. It is also pertaining to sale of the asset during liquidation process as well. So therefore, the benefit of section 32A is essentially to be granted to the successful bidder, and accordingly the NCLT has also allowed it, because see, honestly speaking, the NCLT, there is no need for again approaching the NCLT on this line, because it's a settled law that 32A does apply even for a successful bidder. Next, no action by government authorities for non-compliance for period prior to liquidation commencement date. Obviously, that's also allowed. Then for any violations prior to or penalties, etc., prior to the liquidation process period, then the successful bidder should not be made liable. Of course, allowed. His approvals is fine, investigation is fine. Yes. This is the point I was talking about. Extinguishment of the existing share capital of the company. Now see, as I pointed out earlier, the only authority which has the power to extinguish the extinguish paid up share capital is the Honorable NCLT. There is no other authority in India which can do this. Anyone, even Supreme Court or High Court, will at the most direct the NCLT to do. But the ultimate power of extinguishment is with NCLT. So therefore, that has to be allowed is what they have sought for. And they also sought for issuance of fresh capital at par value to the successful bidder, right? See, the first one is extinguishing the existing paid up share capital of the company. The second one is issuance of fresh share capital to the successful bidder. Now, both of it, they have went ahead and sought the approval from the committee, right? Sorry, from the NCLT. And the NCLT has also given its approval, but however, it says subject to necessary approvals from the SEBI or stock exchanges shall be obtained for, and issuance shall be permissible. However, SEBI, a successful bidder shall seek necessary approval from SEBI for listing of shares, obviously. So this is, see, procedurally, they will not relax anything, but ultimately the relief that the entire existing capital has to be removed is something which they have clearly allowed for, subject to, of course, necessary approvals or no objections from the SEBI and the stock exchanges. Because as per the SEBI delisting regulations, we need to apply to stock exchange for delisting of the shares if we are doing an extinguishment as well as delisting. But if we are doing extinguishment of existing shares and issuance of new shares which will be listed on the stock exchange, then we have to continue to take necessary approvals on the stock exchange. So therefore, extinguishing the existing capital and issuing new capital are two key things which has to be taken care of whenever we are filing for an application before the end. I mean, whenever we are doing sale of CD as a going concern, in the application filed before the NCLT, these two reliefs are ordinarily included. Next, the suspended board of directors of the corporator would stand removed or discharged from the date of issuance of sales certificate. Now see, in the case of CIRP, the relevant date is date of approval of the resolution plan. But in the case of CD, sale of CD as a going concern, the relevant date will be date of issuance of sales certificate. Yeah, Shivaraman sir, sorry, you're asking something.
Sir, I have a doubt.
Yes, yes, sir.
This is with regard to, for example, if it's a public limited company and the shares are held by public at large.
Yes,
what happens when it is cancelled, when it is, extinguishment take place? Existing share capital goes off, means that the fresh shares to be allotted to the old shareholders, or is it they don't have the right? My question is that.
They will not have the right, sir. Yeah, they don't have the right to question. I'll explain like this, sir. In this case, what we are looking at is a listed entity. So in the listed entity, there are a large number of public shareholders. And the plan does not, I mean, in this case, they don't want to provide for any shares to the entire public sector of listed shareholders. So what they do is they extinguish the entire shares. So for example, you and me are public shareholders. Let's say we are holding 10 shares each. So once this extinguishment, we do a corporate action with the depository. Once we complete the corporate action, we will also do a debit of securities. So after both this corporate action for debit of securities is complete, all the public shareholders on a record date which we fix, with effect from the record date, our shares in our demat account, the shares will be deducted. We will not have any right to ask back those shares because it is allowed. It is being allowed under the NCLT order. However, to protect the interests of these public shareholders, what SEBI did was, under its rules, that is Securities Contract Regulation rules, SEBI had mandated to maintain at least 5% of the public shareholding. So SEBI does not say you continue the existing shareholders, but SEBI says you need to have at least 5% of the public shareholding. Now, public shareholders, either you should have QIBs or the existing public shareholders, you can reduce their shareholding to 5%. So two ways we can do that, sir. Today, let's say you're holding 100 shares. They can do a ratio and say every 1 share held by them, every 100 shares held will be reduced to 5 shares. So typically, whatever you're holding will come down to 5%. So 5 in the sense will be reduced by 95%. So like something like that, a formula will be arrived to see to it that the entire public shareholders are being reduced to only 5% of shares. Now, how do we achieve it is by way of this getting such kind of a scheme approved by the NCLT, and the same we will inform the depositories and do a corporate action form. Thereby, your existing shares will completely get cancelled, even though there won't be fresh issuance of shares. The shares, or we can also, in this case, we will do a fresh issuance of shares in lieu of your existing shares. So you will get every 5 shares, only 5 shares you will get by reducing the entire 95 shares. Now, this has happened in Patanjali, sir. When Patanjali was acquired Ruchi Soya was acquired by Patanjali, all the shares they have only give, I think they continued to maintain same 5 to 7% of shares of the public shareholders. So what happened was, if I had 100 shares, it got automatically reduced to 10 shares in my account. So either I can do that, or I can do a complete wipe off of shares and bring in a new public shareholder who can be a qualified institutional buyer, by not more than 5% of shares in a listed entity. Now, if it is a public company, let's say it's not a listed entity, it's a public company, there is no restrictions, sir. Complete shareholding can be wiped off.
Okay,
and
thank
we
you, sir.
will be our own shareholders. Yes.
So now, with regard to this, that means that the it is like what to say, a reduction in share capital, which is happening in the normal course. You mean to say like that?
Correct. And whatever is needed, like we will do procedural things like informing the stock exchanges and filing corporate action forms with the depository. These procedural things we will do, but ultimately we will rely on the NCLT order. No, the reason why I brought this also is that, sir, this is not the liquidator's power. If I sell the CD as a going concern, and the successful buyer says, boss, you remove the shares and give me new shares in my name, I can't do that. Liquidator does not have the authority to do that. So we should advise him that, boss, I will have to file a fresh application with the NCLT for the approval. And we should also keep the SEC informed about the same, so that necessary cost also will be considered for it. And if possible, we should also try to incorporate all these steps carefully in our process memorandum, so that the successful bidder knows, okay, once I am declared as a successful bidder, once I bring in sale consideration, then the liquidator will initiate an application before the NCLT, and only after NCLT allows for extinguishment, the shares gets extinguished. But we as a liquidator can do a directors, we can change the directors. To that effect, at least we can help them. Otherwise, we should go to the NCLT, sir. This we cannot do on our own. No, neither depository nor stock exchange will take liquidator's certificate as a proof for reduction of capital.
Okay, thank you, sir.
Thank you, sir. Yeah. As we move forward, as I said, there are two important things for change of control. One being shares and the other being directorship. So for shares, we have just seen there are two sub-segments under shares. One is extinguishing existing share capital. The other is issuance of new share capital. Both of it we have covered under the point 8 above. And in point 9, here you see the removal of the suspended directors with effect from the issuance of sale certificate, and such persons nominated with the successful bidder be deemed to be appointed on the board of directors. Okay. Now, in this case, typically they went to the NCLT for this approval, but generally, in my opinion, because even the ROC allows the liquidator to file for a change of directors on board. So this, I think, in my view, it is not. It need not be waited till the NCLT approves. The liquidator can immediately change the directors. And if you ask us, did we do it in any case? Yes, we did it. 27th December, we did one case last year where the sale certificate was issued, and immediately on 28th December, we filed the DAR 12 for change of directors, and we licensed with the NCLT Delhi, sorry, with the ROC Delhi, and within 3 days we got the DAR 12 allowed, and the new directors started reflecting on the MCA, and all the existing directors were removed by filing DAR 12. Now, to the extent of change of directors, yes, in my view,
Mr. Prakul, can I interrupt?
Yeah.
This is Rajiv.
Yeah.
Can I?
Yeah, Rajiv,
jump there? Sir, there's one more query in this. Some of the successful bidder are a bit reluctant. Like there is a time gap between the issue of sale notice and getting this order from NCLT.
Definitely, sir. Yes.
Yeah, it would be around 3-4 months, might be anyway, depending upon the bench.
Correct.
So they were a bit reluctant if I can change the director, and later on, if I did not get any concession or any kind of thing, so our liability will come to us.
Yeah.
So so that is why they were a bit reluctant changing the directors in between as well. See, unless I'll get all the approval from NCLT, they were a bit reluctant to change the director at this stage.
I agree, totally agree, sir. In fact, few are reluctant to take control also.
Right,
I have seen cases where they pay some money within 30 days and they ask the liquidator to file the application. They even pay the interest at 12% per annum, but they want this order to be out. I have seen those cases. But I have also seen, sir, equally like in the 2 cases which we are handling, in both the cases, because there is a need to take control, they got the sales certificate immediately taken over as a directors, and the successful bidder themselves have filed an application before the NCLT. So for the relevant reliefs. So this way, but you are right, sir. Majorly,
and there is one more point. Since I am facing the similar issue in one of my
Go ahead.
So there's one more thing. I have already issued the sale notice to them. I have already handed over the control, but now in day-to-day operation, they are not able to change the bank signature of the bank as well, because they have not changed the director. So should I still be in a position to take all this? Because they were doing the operation, they have to do the operations because this company as a going
ideally, yes.
already running.
You're absolutely right, sir. They should do it. Correct. If they are taking control, if they started taking control over operations, they cannot come back to the liquidator for operational issues or signing things. Liquidator should not. That's very risky for the liquidator because we don't have the control. We can't.
These are the practical issues I am facing. That is why I asked this question.
Yeah, I think, sir, honestly speaking, what you raised is the biggest issue for sale of CD as a going concern, sir. IBBA regulations do not clarify anything.
Yeah, they are not ready. Even I suggested to change the director, but they were not ready to change actually as of
that actually they should do that. Yeah, because unless and until there is a director on board, obviously it will be the liquidator only they will come back to for everything. Anybody will ask liquidator.
Yeah,
it's a risky thing for us, sir. If there are operations, it's a risky for
one approach is we normally follow is in the stakeholder committee itself. You know, if there are certain actions which the new management and the directors want to take, list down those actions, saying that, you know, we will need the support of liquidator, and then say that these are being done in good faith to keep this operational or going concern. And let that be acknowledged by the stakeholder.
That it is without any liability, only for the sake of transition. Correct. Yeah, I think that's one via media. But again, yes. Good, sir. So just to quickly summarize what we were discussing, and also what point which Rajiv ji was raising and Anish ji was also discussing, is that typically when we look at sale of CD as a going concern, the major challenge is transferring the control. Now, not every resolution applicant will be comfortable without an NCLT order to take the entire control and operations and change the directors. The reason being liability. Since the directors will have certain liability, they don't want to take up that liability until and unless NCLT allows for the reliefs which they seek. That's the whole reason. So technically, as per Companies Act, there are certain liabilities. Like, for example, last 3 years financials are not filed. Now, if the RA is appointing a director, they are afraid that what if this will come as a disqualification to us, right? So that's why they want some reliefs to be sought from the NCLT so that they can show that NCLT order and take that immunity. That's the major reason. Yeah, Shivraman sir, sorry. Go ahead, sir.
So this is with regard to the bank account operation.
Yeah.
For example, in the case of liquidation, you have to close all the bank accounts and create a liquidation account, right?
True.
Then in that case, what happens? When the fresh share capital or whatever the money comes in, there is no bank account in the name of the corporate debtor. It is in the liquidation account.
Correct.
My question is that then what happens?
Okay. Sir, typically, as you rightly said, we close all the bank accounts and wipe off all the monies and distribute even the cash balance, whichever is available. That is in any general liquidation mode. But when we are looking for sale of CD as a going concern, ideally, we should not try to do that. If there is a current account based on which we are running operations, as we have seen a while earlier, that any going concern under regulation 32A, if there is a going concern, the liquidator in consultation with the SCC will take a decision on continuing the operations. That will also include continuing the operations of the bank account. So if the current account is linked with all your GST payments or the PF deposits or the payment receipts of payments from the customers, etc., then the current account should continue to operate, sir. That is point number one. We should not try to close in liquidation also. Now, point number two, in a second scenario, let us say there is no such operations as such. And we also seen many cases where the company has honestly no operations, but we still do a sale of CD as a going concern for various reasons. Firstly, for the sake of taking benefit of carry forward losses. That is also one of the things which we do. Or for any other reason, we do a sale of CD as a going concern, in which your situation is very likely to arise. That maybe in the first 1 month or two, so we will try to close off all the liquidation account, all the bank accounts, and open a new liquidation account. That is definitely there. But sir, in such cases, what happens? Firstly, the sale consideration from the successful bidder will flow directly into liquidation account. That is fine. And liquidation account is also opened in the name of the company, but still the amount flows into the liquidation account. That has no problem. But once the new successful bidder takes over the company, he like as I said, if there is a change of board of directors, they are very much within their rights to open a new bank account. And with the new bank account and with a new subscription account, they can make compliances for equity infusion and allotment of equity, etc. But that's only a procedural thing. So even though the liquidator closes the accounts, if they are non-operational, he closes the accounts, and then obviously the successful bidder will have a right to open. But if the company is operational, then liquidator should not ideally close the accounts. He should inform the creditors that there is a need for continuity of this account, since we have to hand it over to the successful bidder, since we are exploring the sale of CD as a going concern, and he has to continue those operations, sir, even the operation of the bank accounts.
Okay,
fair, sir?
Fair.
Thank you. Next. Yeah, and of course, this is a standard point. Honestly, this need no mention, but still, generally what happens is, in a CD as a going concern, there is no point of continuity of security interest, because already the security interests were relinquished in favor of the liquidator. That would have been the situation, or the secured creditor would have continued to enforce the security interest on their own, right? So if they have already relinquished in favor of liquidator and the CD has been sold as a going concern, in such a situation, all these assets, we will also be in a position to, it is deemed that the creditor will not have any right over the secured asset. That's the whole idea. So once that relinquished in favor of the liquidator, there is no security interest which continues in favor of the creditor. And once we make the payment to the creditor, so to the liquidator, that's it. It's a single shot deposit of money which we do. And once we deposit the money, there would not be any situation where the liquidator can come back and say one of the, the majority of creditors want something or they don't want something. There is no such majority, etc. involved when there is a sale of going concern. Sale of going concern, as it is a public auction, you're a successful bidder. That's all. You make the payment, the entire CD has to be transferred. They have no other option. Yeah. So there's someone who is raising the hand, sir. Sorry. Debi Sarangi ji. Okay. Was it accidental, sir? Okay. Right. So this is one such order which we have seen in the CIRP situation, sorry, in the sale of CD as a going concern situation. And similarly in NCLT, so this is based out of NCLT Hyderabad. Sorry, NCLT Mumbai is the order which we have seen. But let me take you to one more order, which is of one second. Yeah.
Yeah.
Just opening.
Sir,
Yes,
Devi
yes, sir.
Saran.
Yeah. Go ahead, sir.
No, sir. Uh,
Sir, some should be some issue with your mic, sir. I'm unable to hear you clearly. I just saw that you were raising your hand. That's why I thought you have some question.
no. Thank you, sir. Thank you.
Okay. Thank you. Okay. Okay. Now, coming to just one brief case study, which based on our experience under this sale of CD as a going concern. So we were helping one successful bidder for transition, as I was explaining. So in that, it's actually the success. The corporate debtor was actually a company undergoing liquidation process. Okay. Now, sorry, it's a listed entity undergoing liquidation process. Now, the challenges generally mount whenever the company is a listed entity. The reason being, the compliances of a listed entity are perennial. So we need to keep doing the compliances irrespective of the stage of our process and etc. So even though, of course, there is a good amount of relaxation to the listed entities, honestly, the stock exchanges or the SEBI are very cooperative in terms of revival of listed entities, because they also want that the listed entities continue as listed, so that the credibility of the securities market is also maintained. Nevertheless, there is the general tendency of all of us, majorly the IPs and liquidators, because of lack of budgets, we give a backseat to corporate compliances. Though we give the highest priority to IBBI compliances and CIRP related or liquidation process related compliances with NCLT and IBBI or IPA, but the corporate compliances usually take a backseat, majorly because of challenging situations like budgets, and of course other, like for example, one of the case which I was working on, like there the financials were not finalized for last 5 years, and the successful bidder was adamant that you need to finalize the financials, otherwise I'm not going to take over this, take control over this company. Now see, where come the liquidator will suddenly come and finalize all the financials? But yes, are we doing it? Yes, of course. We are getting it done through an auditor by showing a disclaimer of opinion and getting all the financials closed. Now, before the 5 years, we don't have the books of accounts also. And based upon the closing balances of that particular year and the existing balances, the auditors are doing their reverse working, or the accountants are doing the reverse working, and nobody certifies the authenticity of those numbers. But it is only for the sake of compliances that we are getting it done. Right. So typically, in a case of sale of CD as a going concern, the pending compliances also play a critical role, because going forward, it's not getting dissolved. Had it been a case of dissolution, nobody cares about the compliances, honestly. Even the NCLTs are not digging much into the pending compliances. But since it is a sale of CD as a going concern, if the RA raises this issue that, there are not lots of issues on non-compliances, and that's going to have a problem on us at a later stage, then the liquidator might also be in soup. So therefore, whenever we are handling a listed entity, I know many of us are already doing it, but also my suggestion, and all of us also have to ensure that the corporate compliances are also taken care to the extent we can manage by virtue of having a consultant for that. And also, the disclosures of the stock exchanges have to be regularly provided for, be it under the CARP process or the liquidation process. Regular updates to stock exchanges has to go in as a matter of materiality, right? So that's when the shareholders of the company are also aware what's happening with the company in terms of liquidation. right? So this is one part with respect to the compliance's sake. And yeah, so just to quickly
in addition to
Yeah,
corporate compliances, we have this GST and TDS also.
Absolutely, sir. You're very true. Because if that is not done, there will be huge problem on the successful bidder. Absolutely right, sir. The GST and TDS compliances, and also one more challenging thing I see, sir, is income tax filings. Usually, the income tax returns are not being filed. So the new successful bidder or the RA, when they step in, even if they want to take advantage of the carry forward losses, filing of income tax returns will become a very critical thing for them. So I think you're absolutely right, sir. Even the statutory filings will have a great role to play whenever we are transferring this on a going concern. Yeah, Gaurangji, boliye, sir.
Sir, my query is regarding the provision under Regulation 2B of the Liquidation Regulation, which provides for 90-day window to explore the scheme of arrangement and compromise.
Yeah.
Can you explain what are the practical difficulties in implementing that?
Absolutely, sir. First and foremost, sir, under IBC, on a very funny note, the timelines which are imposed on the liquidator are extremely stringent. But typically, the timelines which are followed in the process are quite, distinguishing. Like if you see, as I think this is what you were trying to point out. Yeah, Regulation 2B, wherein it says this compromise or arrangement shall be completed within a period of 90 days from the. This is the provision you are trying to highlight, no, sir?
Yes.
Yeah.
And there is a further amendment in that. Once this COC decides that the company should go into the liquidation, till the time of the order is passed, the liquidator or RP can explore the possibility
of a compromise. Correct.
Yes.
Yeah. So here, if you see what it says, this is exactly the amendment which you're talking about, which has come in CARP regulations, but a consequent amendment they made in liquidation regulations as well. Yes. So now we will talk about both the situations, sir. Let us talk about first situation where, let's say, during CARP we never explored, and suddenly under the liquidation process we are exploring it. The major practical challenge when it comes to compromise or arrangement is that, sir, generally, if you see the past, if you see how schemes under Section 230 are being dealt with, schemes of compromise are extremely low. You will find a lot of schemes of arrangement. Of course, arrangement is a broader terminology, but still you'll find a lot of scheme of arrangement where both the strategic parties are coming forward, merging into new company, demerger, amalgamation, all that. But a scheme with creditors is, even though it is there since 1913, 1956, 2013 Companies Acts, nobody actually used it much when it comes to settling with the creditors. So always the compromise or settlement with creditors was done on a case-to-case basis, on a one-to-one basis. But since this compromise which we're talking about here is actually settling the claims of all the creditors, so therefore this is actually a new practice as such, which not many of us are acquainted with. Number one. Number two, even though this has got the same phase of a resolution plan, but the requirements of a compromise or arrangement are slightly different. In the sense, the compromise or arrangement, majorly the expectation from the creditors will be for an immediate settlement. Now, that is where actually I have seen that the major reason why this compromise settlements or anything takes time, sir, is creditors expect upfront, while the ones who are submitting this compromise or arrangement will try to also pitch in for a deferred payment. Now, this negotiation usually takes a lot of time, sir. The expectation from the creditor versus what is proposed from the market or from the PRAs. Now, this is, in my opinion, this is point number two, where the expectation of the creditors under liquidation will always be an upfront, even though a lesser value, but they want it at upfront. Because the company is already under liquidation, they don't want to take any further chance. Whereas, if depending upon size of the company, few bidders will be looking for acquiring this scheme, acquiring by way of submitting a scheme on a deferred basis as well. So these two, again, the timeline involved. This is also one of the reasons why they take more time to negotiate within the 90-day time process. Because in the 90-day time process, firstly, inviting interested parties to submit the compromise or arrangement itself will take at least 30 to 60 days. So therefore, the time for negotiation is extremely low, and approvals for that also become extremely low. I mean, the time required for approving a final scheme also will become extremely low. That is one point, sir. Next thing, yeah, sorry. You were saying something?
I think, in my opinion, I think the main stumbling block is the approval of the shareholder, because the promoters are holding. For
Yeah,
such type of
absolutely.
scheme, 75% is the threshold.
Secured creditors 75% has to approve, and otherwise also before has to approve. Correct.
So that approval of the promoters and the shareholders are stumbling block in implementing such type of the scheme.
Understood, sir. But sir, I mean, if probably what I'll do after, maybe if you are okay, we will connect after this session.
Yeah, sure.
I have seen couple of orders where the approval from the shareholders, because they are when it comes to liquidation, since the compromise will propose for removal of shareholders in any which ways, and they do not hold any stake in the SEC. I have seen couple of orders where their approvals or rejection has not been taken into consideration. So I will try to share those orders, sir. Typically, they will not try to, I mean, the intention is not to give control to the members of the company to decide on this, because as per the CARP under section 30 subsection 2, how for implementing a plan, the shareholders approval is deemed obtained. Similarly, under compromise or arrangement, in my view, the decision is only with respect to creditors, which does not include the shareholders of the company, because there is the liquidation value per se is highly depleted, is what is my understanding from those orders. I will try to share those orders, sir. We will see if we can connect and discuss on it. That's an interesting area to discuss. Yeah.
Sure. Thank you.
Thank you. And just an extension on this compromise arrangement is that, because as per Companies Act, we need a class-wise cram down. That is, we need to put on vote on a class-wise basis. That's where we see a difficulty of putting vote for OC separately, FC separately, within FC secured, FC separately, unsecured separately, and within secured we need at least 75% approving the entire plan, etc. But even beyond this, NCLTs have approved the compromise or arrangement where, as a whole, as a class, they have, like all the creditors together have given at least 66% approval in accordance with IBC. And how they interpreted it is saying that there has to be an harmonious interpretation between the Companies Act as well as the IBC regulations, and thereby we cannot stick just to 3/4 voting. Even the 66% voting of majority under the IBC should be given its importance, is how they have interpreted. So I think since of course the topic is on going concern, we will look at that. But I think Gaurangji, we will discuss on that. I'll share those orders also. It can be a fruitful discussion for us. And also, I think the proviso provides for much lesser timeline, because whenever the COC takes a call to go ahead with the proposal of compromise or arrangement, exploring it during the CARP, they will be left only with 30 days time to file it with the NCLT. So the idea is they should not once they start exploring the possibility of compromise or arrangement, even before liquidation order comes, then they should not wait for 90 days after the liquidation commencement. They should finish all their negotiations, etc., even before. And once the liquidation order is passed, within 30 days, they have to file the application before the NCLT. That is the idea. So that's about it. And yeah, so within 90 days, we need to file an application as a requirement for compromise or arrangement. So this is about the situation on compromise or arrangement. Anyways, okay. Now, as we have seen under sale of CD as a going concern, just a quick recap with respect to regulation 32A and also, of course, under 32, is that this sale as going concern should be endeavored to be sold in the first sale. That is, whenever you go and hit the public market for the first time, that should be the first time where you are exploring this concept of sale of CD as a going concern. And if you want to sell the CD as a going concern exclusively, that can happen only at the first auction. Now, after the completion of the first auction, you need to mandatorily go for giving other options also. Suppose your first auction fails, from the second auction, you, along with sale of CD as a going concern, you also need to provide other options or manners of sale for assets of the corporate debtor. Now, this is with respect to the going concern one. And apart from this, we have also seen the practical nuances when it comes to sale of CD as a going concern. That is for change of control, which involves two important things. One is change of board of directors and one is change of shareholders. When it comes to change of board of directors, the liquidator will be within his rights to change the directors as per the nomination received from the successful bidder. But as one of the participants has rightly pointed out, practically in many of the cases, the successful bidders have this reluctance to change the control till NCLT gives necessary reliefs and etc. And just one more point over here is all these necessary reliefs we should ideally ask from the party, that is ask from the successful bidder himself. But in few cases where a successful bidder is not backed by any legal support, he's only come up by way of submitting this bid on his own, then the responsibility a bit comes on us as liquidators to guide them in in even ensuring guiding them as to what kind of reliefs they have to ask from the NCLT. So the role actually is quite interesting whenever we do a sale of CD as a going concern. And two important documentations I always suggest for all the liquidators whom I work with. One, the process memorandum. The process memorandum has to very clearly highlight our limitations of role as a liquidator. Because generally, once the sale is done, if there is a rift between successful bidder and the successful bidder will first run through what is there in the process memorandum. If there is any loose end clauses, they will come fighting for it, saying that only because of this we have bid karke. So it is always important whenever we are going for a sale of CD as a going concern to carefully define things, to carefully explain things, and to carefully highlight the limitations of the role as a liquidator when it comes to transfer of control. And if this is a need for going for an application, we have to very clearly indicate that the sale of the making the balance consideration has nothing to do with filing of application with NCLT. There are all the steps involved, like step 1, sale certificate. Immediately within 1 day from issuance of sale certificate, the successful bidder shall nominate the names of the directors, or along with deposit of sale consideration, within a day they have to give the nominated directors, otherwise we will not issue the sale certificate. Something like that we should try to prescribe in the process memorandum. The reason being, when it comes to terms of sale, liquidator has got good amount of discretion. So we should try to use that discretion when we are drafting our process memorandum. Now that is first document. The second document which we have to focus on will be the issuance of sale certificate. The sale certificate should also have the language very clearly with respect to what are we transferring, what are the assets, exact assets which are there as part of process memorandum should be replicated in the sales certificate, or at least a reference to the process memorandum should be clearly provided in the sales certificate. And the sale of the transfer of control by virtue of shares or by virtue of anything else, we need to clearly highlight that a separate application has to be filed with the NCLT. So that way, we have to carefully highlight the requirements under under the sale of CD as a going concern in the sales certificate as well. So these two things are our safeguards as a liquidator. Then subsequently, the bidder will provide us with the reliefs which they need in the process. As liquidator, we also have to run through what are the reliefs which we can grant and what are the reliefs which we cannot. In fact, recently, if I'm not wrong, NCLT Kolkata bench had either Kolkata or Mumbai, but I think more should be Kolkata only, has given an observation that a plethora of reliefs are being sought when it comes to approval of a resolution plan. So it was they mentioned their observation that's something not expected from a resolution plan application. So therefore, it same applies to this case also. So what reliefs we are asking should be limited and should be specific, so that it is easier to explain to the NCLT for for an order in first hearing itself. If we go with too many reliefs which has bearing on multiple authorities, if we go into too much of arguments on that, probably the chances of getting approval for the reliefs will take some time. So therefore, reliefs have to be specific, and in the specific release, we have to ensure that we are providing for required number of reliefs which are extremely specific and which for which NCLTs are used to give orders. So all these prior orders where NCLTs have already given certain reliefs, better to take those reliefs as it is, so that it's easier to tell the NCLT that in a similar case, the same bench has allowed these kind of reliefs. Of course, some additional reliefs can also be put into depending upon a particular industry or a particular case. But as a liquidator, we also have some role in explaining to the successful bidder as to our limitation in bringing forward all those reliefs into the attention of the NCLT. Now, yes, so this is one aspect. Then should we or should we not make the successful bidder a party to the application? I think either ways there should not be a problem, because as a successful bidder, they should also be given maybe they can be made a pro forma party to provide their concerns before the NCLT. That can also be explored. So this is all about sale of CD as a going concern. But when it comes to say closure of the process, so I think I discussed it at the beginning only, but I will take some again. I'll just repeat that concept as well. So once we sell the CD as a going concern, of course we have to move back to of course we have to move back to section 53 for distribution of the funds. So because unlike a CIRP, in a liquidation process, the bidder will not be providing any priority in payment or any distinction or class-wise payments, etc. Nothing. The liquidator, the successful bidder will not have a right to provide higher share to secured creditors or lower share to others. Nothing. As a liquidator, we have to strictly adhere to section 53 and go ahead with distributing the monies as and when we get the realization, and we have to ensure that within 90 days we are distributing all the proceeds, right? And once we distribute the proceeds, we will have to complete the liquidation process, correct? So now for completing the liquidation process, one second, we need to file an application for closure of liquidation process. Now, how do we do that? I'll just show the, I mean, we have just seen that thing right before. Yeah. So we need to file for closure of liquidation process and not for dissolution. So we'll just spend a couple of minutes on this. See, there is a difference between closure of liquidation process and the dissolution of the corporate debtor. The only difference is that in case of dissolution of a corporate debtor, the corporate debtor will cease to exist. It will be removed from the register of companies, register of companies by the registrar of companies, and the company will be wound up. By the order of NCLT, the company is dissolved and wound up. Whereas when we do the sale of CD as a going concern or a scheme of compromise, in any scenario, we are transferring the control to the successful bidder. Thereby, the company is continuing in existence. Therefore, we cannot file for dissolution as a liquidator. So I cannot do two things. No, I cannot file for dissolution as well as do a sale of going concern. That's where the IBBA has introduced this concept of closure of liquidation process. Now, closure of liquidation process is again an application which we make with the NCLT. So this is a separate application IA which we have to file. So that IA for reliefs and liabilities and this IA for closure are two independent IAs. We should never club both these IAs. The IA for necessary reliefs for the successful bidder can continue even after the closure of liquidation process. Therefore, the IA for reliefs has to be separately filed. The IA for closure of the liquidation process has to be separately filed, and the IA for closure of the liquidation process will have a same content explaining everything and what all required has to be done even here, like final report, compliance certificate, everything we will do, but we will file for closure of the process. We cannot extend this for, I mean, we cannot pray for dissolution, but we will pray for the closure of the liquidation process. And once we file this closure of liquidation process, then only the successful bidder of the sale of CD as a going concern can, through IBBI and MCA, change the status of the company from under liquidation process to active on the MCA portal. Now, this we are currently facing a challenge in one of the sale of CD as a going concern, where we are assisting the successful bidder, wherein after acquiring the sale of CD as a going concern, they are unable to file any forms with the MCA because the MCA still shows in the portal, shows the company as under liquidation. Then we reached out to IBBI. IBBI also supported us, reached out to the MCA. Then MCA informed IBBI that then IBBI informed us that unless the liquidator files closure of liquidation process application with the NCLT, IBBI will not be able to put any word to MCA for change of position from under liquidation to active, because they have their own SOPs. IBBA has to send that communication for changing the status from under liquidation to active. And IBBA has its own SOP that until and unless liquidator files a closure of liquidation process application, IBBA will not be able to propose for change of the status of the company from under liquidation process to active. So this is all about sale of CD as a going concern. As I was explaining, it is just a parallel process of resolution plan, just that in a resolution plan, everything is systematic, everything is prescribed, documented, everything is codified. Whereas in sale of CD as a going concern, everything is evolving as a practice. It is not codified under the regulations or under the act. By codified, I mean all the nuances. Just in a resolution plan, you see that all the nuances are carefully drafted in the regulations as well as the act, all the mandatory content, etc. Whereas for a sale of CD as a going concern, you don't have such kind of enabling clauses to give relief to the liquidator. In fact, to give relief to the successful bidder. In fact, if you see section 31 of the IBC, it states that a resolution plan approved by the NCLT is binding on everybody. But there is no such similar clause under the IBC which states that the sale of CD as a going concern will bind everyone. However, the principle what we have to rely on is wherever there is a sale under liquidation by a liquidator, it is an absolute sale. Nobody can question it. So that's a general principle. Thereby, using the same general principle, even the sale of CD as a going concern has been documented. However, rest of it, like filing an IA with NCLT for appropriate reliefs, change of shareholders, what happens to shareholders approvals, what happens to directors, nothing of that sort has been clarified under the regulation. So therefore, we need to, without hesitation, ensure that we are filing something with the NCLT immediately after receipt of sale consideration. So this is something which we have to take care of. And as I said, in one of the orders in NCLT Chennai, I have observed that after the successful bidder has been declared, there is some consideration which has come within 30 days. And for the balance consideration, before the balance consideration kicked in, they filed an application with NCLT for approval of reliefs. Then NCLT had approved all the reliefs subject to condition that, the successful bidder will pay the balance consideration before the 90 days expiry period, along with interest at the rate of 12% per annum for the delay for the period beyond 30 days. So this way, NCLT has directed it in the order. So for a sale of CD as a going concern, liquidator cannot violate the regulations for public auction or private sale, right? So again, coming to the mode of sale, which is the last topic before we conclude. So this going concern can be done either as a public auction or even as a private sale. So if you are doing as a public auction, you know that there is a process prescribed under Schedule 1, wherein you will follow all the steps of minimum 35 days, marketing the asset and giving all the facility, inspection rights, etc., etc., etc. But if you are doing a private sale, then same Schedule 1, what all it provides for a private sale, we will have to comply, and we have to file an application mandatorily with the NCLT for allowing a private sale of the corporate debtor as a going concern, right? So this way, a clear distinction we have to do. And whenever we are exploring private sale as a going concern, what is important for us is to ensure that we are doing at least at least one public auction we should try. So for the sake of price discovery, or maybe 2 times we should try at least for the sake of price discovery. And then if there is somebody who is able to give a better price than public auction by way of a private sale, only then we should try to approach that. Otherwise, NCLTs do not encourage private sales when the same are lesser than the failed public auction. So it's usually better practice should be to first approach the public auction, then only try to explore private sale. So this is about the mode of auction. So even for sale of CD as a going concern, you can still have a mode of auction of private sale, but that will have a subject. It is that sale, or you cannot issue a sale certificate in that case until and unless you get the approval from the honorable NCLT. But if it is by way of public auction, it is deemed that the CD is sold to you as a going concern. Liquidator has got the power to transfer the control to you, but certain complaints things will have a bearing. So therefore, the liquidator will not be in a position to, the liquidator will not have the authority to allow for such things, and therefore you need to approach the NCLT. And just to repeat, with respect to compliances, because it's a going concern sale, all compliances will be expected to be complete in all respects before handing over to the successful bidder. I know majority of our cases, there can be a challenge on completing the compliances, but all efforts have to be put to try to ensure that at least compliances to the extent possible should be complete and handed over to the successful bidder. So this is all from my end with respect to sale of corporate debtor as a going concern. If there are any questions, and I'm extremely happy that in this session I was able to interact with a couple of RPs, a couple of insolvency professionals. It's always enlightening to discuss the challenges faced by us, because all of us have got customized challenges to the facts and circumstances of our case. So I'm thankful to all those insolvency professionals who have shared their views during this discussion on sale of CD as a going concern. And I hope my replies or my answers to your questions and my views make some value to the session. So with this, I conclude from my end. If there is any question from anybody, I'll be more than happy to take it up. Otherwise, we can conclude the session. Over to you, Anjali ji.
Sir, there is one question.
Yeah, Harvinder ji, go ahead, sir.
Once we are closing this liquidation process,
okay,
there are many applications which are continuing. IAs or IAs, for one is buffet, or there could be some dispute on the distribution, or there could be any point of, the applications might be going.
Correct.
So now for liquidation, you need to close the liquidation account and distribute the entire money. Who is going, where the money is to be kept for meeting the cost or dealing with those applications? And secondly, who is going to bear the cost for the subsequent, for the, proceedings and other things involved in that?
Yeah. Understood, sir. So interesting scenario, sir, and also a very practical scenario. In few cases, luckily, if as liquidators we don't have any litigations, then it's a very lucky situation where we can directly file a closure application. But two situations arise, as you rightly pointed. One is pending avoidance transactions. Other is pending litigations or disputes amongst the creditors or between the creditor and liquidator, or there is some receivable which the liquidator is expecting and that litigation is still pending. So we'll try to address each of it. Firstly, the avoidance transactions. So I was trying to highlight this on the screen, Regulation 44A. So what it says is that, sir, when we are filing the final report and the application for closure, so in the same final report, we also have to provide the manner in which these proceedings will be pursued after the closure of liquidation process or the dissolution, and the manner in which the proceeds, if any, shall be distributed. So the idea is, if we all recollect from the CIRP regulations, Regulation 38 provides that the resolution applicant shall provide for this as to the manner in which it will be pursued and the manner in which proceedings will be distributed. Now the burden is shifted to the SEC, saying that, okay, you should not wait for the disposal of these applications to dissolve this company. So you amongst the SEC decide how this will be pursued. One of you will pursue it, Or will you authorize the liquidator as an independent professional to pursue it? Or will you as a cluster, as a joint lender forum, you all will together fight for this? How will you do that? Or do you want to assign all of this to somebody who is willing to acquire all of these avoidance transactions, and that they will be pursuing it and they will enjoy the benefits from it? Or you are assigning it to an ex fellow who is only going to pursue it at a fee, and then once it is recovered, he will distribute the monies to everybody. So what is it that you want to do with this avoidance has to be provided in the application. So now it is a mandatory thing. You cannot say that, okay, I'll file an application and still I will keep it pending. No, you have to first have a discussion amongst the SEC as to how are we going to treat this avoidance transactions. Only then we can file an application with the NCLT. This is with respect to avoidance transactions. Now, other litigations. Now, under other litigations, let us divide it into two. One is litigations against us from any of the alleging party, that is from any of the alleging creditor, seeking, questioning the very basis of distribution or questioning the rights of security interest, etc. Now, suppose that IA is pending, definitely we are within our rights to go ahead and file a closure application, but practically NCLT will not dispose the application for closure without disposing of this particular application filed for dispute of distribution or questioning the liquidator on any of it, whatever it is. Now, in this scenario, let us talk about the cost. Okay. Now, when we talk about the cost, what it typically is, when we are doing the distribution of this proceeds, what I did, at least in few of our cases when we were assisting the liquidator, what we did as a practice is we discussed with the advocate who is appearing on behalf of the liquidator that, boss, you please quote us a single one-time fee, a lump sum fee, basis whatever your estimate it is, which will be paid upfront to you. You might dispose of the hearing in the next hearing also. Probably it may take 10 hearings, it may take 20, it may take 1 year, 2 years, doesn't matter. Please give us one final quotation as to what is the lump sum payment you want to do. Now, there is some level of practicality involved in this in terms of negotiating that fees, and that has to be discussed with the SEC, and that money has to be paid upfront to the liquidator, to the advocate, basis of professional fee for as a lump sum payment for engaging in that particular litigation. Now, I understand it is not easy, as said. At times, SEC might not cooperate for it, but that is a completely practical situation, sir. Like how SEC is responding to this, but ultimately, obviously, liquidator will not take a hit on the expenses for litigation on the corporate debtor. So that is nothing for us to do. So therefore, in my view, it is better to get a quotation to handle the entire pending litigation for the rest of the time period. But generally, because the reason why I'm telling that is, until and unless we do that, ideally, we should also not distribute money to the creditors. If we really realize money, we should keep it pending till SEC decides on all these costs. Otherwise, once we distribute, nobody is going to come back to us. So therefore, prior to distribution of money, we need to keep this budgeting, and budgeting with the proper backing up and professional invoices which will come from the professionals. Because if we keep it under budgeted, then the budgeted money will again come back to the, suppose the budgeted money is distributed to the liquidator so that the account is closed, it will become for us to maintain accounts for it, and then any balance again we have to distribute back to the creditors. That will become a problem. So better not to keep anything open before we start distributing the funds. That is one part of it, sir. Second is, as you said, correct, we will usually close our account. So we will not have any account into which this monies have to flow. So for avoidance transaction, that's why the creditors have to decide how that will be proceeded. Maybe one of them will be nominated to receive the funds. But in case of other litigations where we are expecting some receivable, generally, if we are expecting some receivable and we are fighting for it, we cannot file for closure of an application because there is already an asset which is unsold. So when there is an asset unsold, we cannot file an application for closure or dissolution. So therefore, the situation does not arise. Either we have to sell it as a not readily realizable asset and then file for dissolution, or we have to continue fighting for it. And until and unless we win that or lose that, we cannot close the process. That is about it. Now, other litigations, as I suggested, sir, in where there are litigations, depending upon the situation or depending upon the seriousness of the litigation, we will have to decide the strategy and the cost which might be incurred towards it, and better to get an advance, an upfront payment done to the lawyer who will continue the litigation. And if SEC is not allowing to incur that cost on the lawyer and they are okay for the repercussions of it, then as a liquidator, we have to take a call to clearly inform that, or inform the NCLT also, that I do not have any cost approval for a lawyer. So therefore, we will have no other option but to appear on our own if there is a case against us. If there is a case against the very basis of distribution and something being questioned on us, then we have to adhere to what NCLT directs us. So generally, sir, my point of explaining this in different levels of litigation is that for avoidance transaction, the route is clear under Regulation 44A. So this is fine. Other litigations majorly will be on this. Either the claim is not admitted properly, or the security interest has not been done taken care properly, or 53 is not adhered to properly by the liquidator. So it is usually a long-drawn litigation which is known to us. So at such situations, better to have a lump sum fee from the advocates and propose it before the SCSC, convince the SCC that, if without this, I will not be in a position to distribute the funds, get the approvals, make the payments even to that advocates, etc., and close the process. This is my suggestion, sir.
Sir, any practical order or anything where NCLT has, given any direction, or practically somebody has dealt it, and it is only what we have discussed is just your observations or your suggestions. Are you aware of any practical situation?
I did this in my case, sir. I did this in my case, but NCLT per se usually do not, unless and until, so generally, if at all, our fees is not being paid or the lawyer fees is not being approved, then NCLT will direct SCC only. That's a normal scenario. But I don't really, this situation of dissolution part, I don't know if there is any precedent, sir. Because generally, before dissolution, all these things, they'll try to close off during the SCCs and go for a dissolution. Particularly the cost parts, direct negotiations between lawyers or the SCC, they will do. Otherwise, I don't per se remember or recollect any orders from any NCLTs with respect to meeting of costs. Meeting of costs, yes, but it will be not at the time of this litigations, at the time of dissolution, because at the time of dissolution, they assume that SCC has already taken that into consideration. Otherwise, as liquidators, we have to bring it to the notice of NCLT by an IA to give direction to the SCC to meet that cost. But ultimately, the cost has to be met by SCC. That is the thumb rule, sir. There is nobody else who should meet that cost.
Okay. In fact, now in our case,
I am from Mumbai, and I acted as liquidator in one case.
Yes, sir.
Currently, I am handling. My dissolution application was filed in 23, sorry. And thereafter, several hearings took place, but the matter is yet to be disposed of by NCLT. And in the meantime, I had 1, 2, 3 disputed cases. Those cases also got resolved, sir. 2 arbitration cases were filed in subsequent to my filing of dissolution application. 2 arbitration matters were filed in High Court, Mumbai, with respect to my sale as liquidator of land and building. That also got resolved in my favor, sir. And one employee filed case because as they could not realize anything in dissolution, they also filed a case. That also got disposed of in NCLT, Mumbai itself. And we assigned our NRRA, including PUFE, which was to the tune of 32 crores. Even that was subsequently successfully assigned to a third party. But no, I am facing a difficulty that I am getting always a new date from NCLT Mumbai. Now it was filed in 2023, and today, and after my filing of dissolution application, I got a lot of litigation from income tax, from GST. But since they are unsecured, so they have not so far approached NCLT. They have not so far filed. Because of this delay, I apprehend that I get some additional litigation, but nothing is pending from my end now. So how to deal with this situation, sir?
Sir, honestly, NCLT's delays are something which we all are, particularly Mumbai. I don't see a solution at all, sir, unless the NCLT members take it up seriously. Like my own case in NCLT Mumbai, one of the resolution plans, very small plan, less than 1 crore of resolution amount. Since last year June I filed, sir. This is 1 year and no hearing are they given even an opportunity to speak. They're saying it's a small case. We don't want to listen now. We will listen on a later date. That's all. Simple. So I myself, I really don't know what is the solution for it. But I think IBBI, he's trying its efforts to bring the list of pending cases to the notice of NCLTs from time to time. That much I think you also would have received emails from IBBI asking for information on the pending cases, and
Sir, there is another risk. If there is some irregularity or something which we could correct immediately, but after 3 years, if you point it out, then it becomes very embarrassing.
Correct.
We cannot go back and do those corrections.
True. And in fact, you're absolutely right. And they indeed come up with such kind of observations also. If the same observation was made 2 years back, probably would have been in a position to get some information rectified. But now it will be difficult.
And sir, insolvency professionals are now reluctant to take new cases because of this, sir. Because once you get into it, you are not coming out of it.
Yeah, absolutely, sir.
Because of this is very big threat to the liquidators.
Yeah. And we are continuing as liquidators, whereas SCC has got his money distributed, they are out of picture. But we continue to keep a track of the cases. Here we have to attend all the hearings, and then if we are not attending a hearing, at times we get notices, asking the liquidators to come for the hearing. So you're absolutely right, sir. It's such a tough thing. So Harvinderji, you were asking something else also, sir, in addition to the earlier one.
Yeah, I was telling that in our case there are a lot of recovery proceedings by the corporate debtor against the debt. Various from where the debt is due to the company.
Okay.
So those are going on for years. No, it is almost 10 years. The cases are going on, and they will continue going by the trend. They will continue. So that is also it is a never closing state of affairs. So there is a practical situation very difficult to handle, and nobody, as you said, SCC and this and that, nobody looks it seriously. It is coming on. You have to be there, because you can't wait for SCC to take a call. If there is a date, you have to be there. Your advocate has to be there. The cost involved has to be met. So from where these are the things which needs to be looked into very seriously, which I think are not taken care in the way, even though the IBC has evolved for almost now 8 years.
True. Yes, sir. Thank you so much for sharing your views, Jagdish ji and Harvinder ji. Any other points to discuss from anybody else? Yeah, thank you, sir.
Hello.
Yeah.
Sir.
Sachin ji, go ahead.
Sir, a query other than for liquidation.
Okay.
It is related to Limitation Act. Can we discuss?
Go ahead, sir. Let's see.
Yeah. In one of our cases, we are appointed as a insolvency resolution professional recently. The application for CIRP was made by the operational creditor in 2018. And the application got accepted in 2025 by NCLT.
Okay.
The company did not made its books of accounts since 2021.
Okay.
Right. Now the company is saying that no debtor or creditor, neither company made any claim to its debtors in last 3 years, nor any creditor made any claim from company in last 3 years. Actually, it was in 2018, the operational creditor took the company in NCLT.
Understood, sir.
And the application got accepted in 2025, right?
Understood.
Now, we have to get the clarity. Will the debt of the operational creditor who got the company is the debt in limitation or out of limitation?
Understood, sir. So, like if I have to I'll just repeat what you're trying to say is, if at all because in this case, 7 years, it took 7 years for the company
Yes.
to come to CIRP. Thereby, within
Yes.
these 7 years, there was never any acknowledgement of debt. Therefore, can we
Yes.
take a view that the claims are barred by limitation? In my opinion, no, sir.
Yes.
Firstly, particularly the OC applicant, the reason being the limitation is for invoking a remedy, sir. So
Right.
they invoked the remedy within 3 years. Now,
Yes.
filing of claim in various orders, it is held that filing of claim is not a remedy, but a right. Oh, sorry, it is not a remedy, but their obligation as a claimant and also a right as a claimant to file. So even if you see under Limitation Act, your right is still intact, only the remedy is taken away from you. So filing of a claim is not a remedy. So when filing of claim is not a remedy, the question of limitation will not come with respect to claim. As long as the books of accounts contain the certain amounts as claims, that has to be as a RP, as we do not have any adjudicatory powers, the IRP should allow such claims as long as the books record the claims, irrespective of whether they have invoked, not invoked their rights, or they have taken any remedy, not taken any remedy under limitation and all. So that's my view, sir. So
Okay. Actually, in our company, the company had a secured creditor also.
Okay.
But after the OC applied in NCLT, that application was not accepted, and the company sold its plant and machinery, etc., and settled its secured debt.
Okay.
Books of accounts are not ready since last 4 years.
Okay. So yeah, challenging, sir, definitely. But limitation angle, maybe other RPs, if you have any views, you may also share, sir. In my view, limitation angle, we should not bring in, particularly at claim verification stage. Because claim is not a remedy, it is a right, and a right will continue. We will admit the claim. Now, as a resolution applicant, somebody who is considering, if they don't want to, they want to take a chance saying it is out of limitation, that is their headache. That is also not allowed ideally, because they have definitely within their rights invoked the provisions under Section 9 under IBC within 3 years' time. So today, as a RP, IRP, we cannot change that stand or limitation. But for others also, suppose there are other operational creditors also, we should still allow them to file their claims. Now, CD cannot tell us that it is beyond limitation. And if CD has not maintained the books of accounts, today we have to direct them to maintain. Otherwise, we have to file a Section 19 application against them for not providing the information.
Obviously. Okay, sir. Thank you.
But
Thank
I
you so
think,
much.
the chances of, as you rightly said, since they've already sold off all the assets and paid off secured creditors, sir, then I think you should strongly look into Section 43, 45, all those avoidance transaction provisions. If at all they're falling under that period, only, if there is since it's secured creditor, it's fine. If at all any payments are also made to other directors, other unsecured creditors, I think this might come. So you may have to carefully analyze that, sir.
Sir, which period we should consider in that case?
Generally 2 years preceding today, but for Section 66 fraudulent, even we can go up to 5 years or more also. So if we see any fraudulent thing that we can do, but 2 years prior to today, suppose if the sale is happened between
Sale happened in 2021, sir.
At 21, then I think 43, 45 are gone. We can only rely on 66, sir.
Right.
Yeah.
Okay. Yes. Thank you.
Okay, thank you. Okay. Any further questions? Anjali ji, I think if there are no further questions, we can conclude the session now. Anjali ji, can you hear me?
Yes, sir.
Yeah. We are done with the session, ma'am. We have taken up questions also. If there are no other questions, further questions, we can conclude the session.
Okay, sir.
Yeah.
Participants, if there are any questions, then you can ask. Then I think we should conclude.
Yes, ma'am.
Thank you very much, sir, for taking out time and addressing session on the topic sale of corporate debtor as going concern.
Yeah, ma'am. Thank you.
Sir, you are requested to please share whatever the material you have.
Yeah, I'll share, ma'am. I'll share the orders which I have referred in the class.
Thank you so much, sir. Thank you.
Now there is break till 2 p.m. Next session will resume at 2 p.m.
Okay, ma'am. Thank you.
Thank you very much, sir. It's
Okay.
an
Thank you.
Thank you very much, sir.
Thank you.
Yeah, it's
Thank you, sir.
excellent and it's very valuable to us. Thank you very much.
Thank you, Bhuvneshwari, ma'am. Thank you.
if anyone can revert by what time they are starting it?
Two p.m.
Okay. Thank you, ma'am.
What time we are starting the session?
Madam, nobody is joining, I think.
Yes, sir.
I
Surprise.
don't know. We are sitting idle for this. Is there anyone from ICSI? I don't think anyone joined from their end.
Now, has this session started or it is yet to start? Anybody there?
Sir, it will start.
Okay, thank you.
Madam, shall we start the session, ma'am?
Yes, sir. Shall we start? Participants, shall we start now?
Please.
Yes, please.
Good afternoon, everyone. Now the session will be taken by S. Dhanapal, sir, on the topic practical intricacies faced during liquidation process. Let me introduce Dhanapal, sir. Sir is CSIP law graduate from Dr. Ambedkar Government Law College, Chennai, and commerce graduate from University of Madras.
Ma'am?
Currently, he is founder and managing partner of S. Dhanapal and Associates. He has overall experience of more than 24 years in area of corporate, secretarial and legal matters. He has been mentoring corporate as well as professionals with his wide experience, knowledge and professional acumen. He regularly contributes as speaker and writer in various professional forums and journals. He is well-known resource person, having addressed as speaker in over Am I audible, sir?
Yes, you are audible.
Yes.
Okay, we are once again starting. Now, Dhanapal sir is taking this session on the topic practical intricacies faced during liquidation process. Let me briefly introduce Dhanapal sir. Sir is CSIP and law graduate from Dr. Ambedkar Government Law College, Chennai, and commerce graduate from University of Madras. Currently, he is founder and managing partner of S. Dhanapal and Associates. He has experience of more than 24 years in area of corporate, secretarial and legal matters. He has been mentoring corporate as well as professionals with his wide experience, knowledge and professional acumen. He regularly contributes as speaker and writer in various forum journals. He is well-known resource person, having addressed as speaker in over 200 national and regional forums throughout the country, in various professional institutes, chambers, universities, colleges and other places. Now start the session, sir, please.
Thank you, madam. Thank you for your detailed introduction. Good afternoon, all. Today, the topic which we are going to deliberate is on the practical difficulties that in liquidation process. I think today almost some 45 participants are there. Hopefully, this shows how much interested we are to discuss on practical difficulties. Though many faces I could not see, but still, at least the presence is there. So I'll be happy to share my experience, also to hear your experiences also in the liquidation process matters that you are handling. Now, before proceeding further, I thought today it's not like a session where we need to understand the legal provision under insolvency bankruptcy code, because I believe all of us must be practicing, means you all must be practicing like me, and you must be by now thorough the provisions of the law that I'm sure about almost 8 years of after introduction of insolvency code. We are now at least settled with some process, but still we are facing difficulties. That's why we are sitting here to discuss on the practical difficulties what we are facing in liquidation process under insolvency bankruptcy code. And before starting the session, because I have my own experience to share and I have many other experiences on the verdicts and case laws and what are the developments that has come and new introduction of law, and I've got my own PPT and many things are there, but still I thought let's try to take this session in a very practical way and understanding the getting the solutions for all our practical problem rather going into monotonously the provisions of the code, which almost everybody would have gone through. Okay. So at least from some of you here, can you share what are the real difficulties, or we can rather say a crucial or important issues that we are facing as a liquidator? Anyone in the group? Because morning, we have discussed our earlier speakers deliberated on the sale as a corporate debtor as a whole on a going concern basis, but where he is nicely addressed on legal provisions as well as all the orders of the NCLT and other practical things. But here we are purely going to deal with only the difficulties that we have faced in the entire process, not only on particular aspects, right from the date of liquidation commencement till the filing the dissolution application or closure of liquidation process application. So can I hear or get from someone who really have important issues?
Sir, I can add something here.
Yeah.
I was appointed as liquidator in 2021.
Yeah.
March 2021, and after great difficulty, I could, because that time it was the under COVID period actually.
Okay.
But despite that, I physically paid visits to the factory, and I could sell all my assets, assets of the corporate debtor.
Okay.
Although we could not get much response, but plant and machinery, land, building, everything I could sell. And finally, now I filed my dissolution application in July 2023.
Okay.
And thereafter also I faced a lot of litigations. One employee matter was there before NCLT bench, and 2 more arbitration matters came up in Mumbai High Court. Those matters also got disposed of in my favor.
Okay.
But no, now 3 years down the line, still my application is not approved in NCLT.
Okay.
That is my challenge now.
That's I believe that's a challenge. Everyone faces that challenge.
And I am actually running the risk of getting more litigations from income tax, GST, or other departments. That is a bigger challenge.
So one thing I can try to help deliberate on income tax and GST aspects, and what are the cases which are in favor of us or in favor of the liquidator. I'll try to put on those matters before you, or what are the matters which I come across and which will help us as a liquidator to deal with income tax matters and GST matters. In fact, my idea itself is to deal with the real difficulties that we are facing as a liquidator. Okay, though certain difficulties are kind of handling the corporate data, handling the promoter or other things. Certain difficulties are claim and government department claim, all that. So of course, we can list out the difficulties that we are facing more, no doubt at all. But let's try to understand, out of this deliberation that how to deal with certain specific difficulties. As you said, the income tax and the GST. What is the kind of case that they filed? Any TDS issue or tax issue?
Sir, tax issue, regular assessment. They are now doing assessments and coming out with more liability. Although I have accepted their claim is unsecured, and distribution, everything is over, and they could not realize anything, but still they are coming out with more liabilities and assessment. Year-wise, they are doing assessments. And pre-CRP period, sir, pre-CRP period.
Okay. When they commenced assessment?
Sir, assessment was commenced even before CRP period. But now they are freezing, they are coming out with the liability. And the corporate debtor filed appeal also. But I do not have any information in hand. So I am merely responding that this is too late now. And at this stage, too, I cannot even accept their claim.
From the issue that we are discussing, I could understand that the assessment has initiated, assessment started by Income Tax Department before commencement of CRP, right?
Yes. Yes, in some of the cases. Because every year they are doing, no?
Correct. So they, but have they filed the claim in CRP?
No, the claim was not filed and they are actually now doing assessment. Assessments were not over.
Oh, okay.
But whatever they filed, those after verifying at my books of account, I accepted that. But now dissolution application itself was filed in 2023. Now we are in 2025. So at this moment, it is impractical for me to entertain any claims.
So still they are doing the assessment only, or not quantify the tax dues?
Still they are insisting me to file return of income.
No, return of income. Good.
Yes.
That's a clear. Okay.
Yes.
I'll share you the case during the session. I will share you the bunch of cases. Okay.
Thank you, sir.
Which really help us in to prove our matters, means to prove our merits before the income tax department and GST department. I'll share few cases on that. But before that, to share my view on that, see, the section 53(1) is very clear. Directly, it is very apparent and clear that the due should have been 2 years prior to the liquidation commencement date. Am I right?
Correct.
The due.
That is for employees, no, sir?
No. You just see.
Okay.
53(1). I'll show you that.
Okay.
Started. I will take you to that. Wait. I'll share and I'll take it. It directly hit the provisions of the regulations. Just updated up to, yes. Can you take 53? Can you take 53? So that I can easily explain to you. Yeah, I want to show you, but little later I will show you.
Yes, sir. No worries. No worries.
No, this 53 directly, if you can come to the 53. No, right now I'll tell you what it is exactly. Then I'll show you the cases and other provisions and all related to that. It directly hit provisions of section 53, wherein any amount due to central government, state government, the amount to be received on whatever, if any, in respect of whole any part of 2 years preceding the liquidation commencement date. Okay, their demand or whatever their claim will fall squarely under E. Is it not?
Sir, it is anyway. It is unsecured, no, sir.
No. Anyway, it is unsecured. That's it. But their claim directly falls under E.
Okay.
So
correct.
That means the point here is that the dues should have, in respect of a period of 2 years preceding the liquidation commencement date.
Okay.
So that means the due should have been ascertained.
Right.
Okay. So idea, see, the word used is due. So when you do assessment, the income tax department, when they do assessment today, that means they are going to ascertain the due today. They have not ascertained the due.
Correct.
You understand my point?
Yes, I understood.
So wherever the matters or cases where the assessment is done by income tax department, what they have to understand is that they are supposed to ascertain the due well before 2 years prior to the liquidation.
Liquidation. Correct. So now at the moment they cannot do that.
Exactly.
So now it's too late.
The idea is that you can't keep on doing parallelly do when the liquidation process is going on. You can't parallelly do your assessment, no, because there is a process in place. The claim has to be filed and it has to be verified. It has to be adjudicated and accordingly, assets should be sold and distribution should take place as per the claim accepted.
Correct.
So how could when assessment is done today and claim given today or demand is raised today by any department, government department, can be accommodated? unless they file a claim well early and it has been accepted by the liquidator, then only the liquidation asset, the realization of the liquidation asset could be used to settle proportionately whatever the realization, based on the realization. So that means, it is very specific, very clear. There is no, question of interpretation here or doubt here.
Yes.
All the claims of government department supposed to be the due prior to liquidation commencement date.
Understood, sir.
Okay, that means the due ought to have arisen before 2 years from liquidation. Anyway, I'll show you cases before during the deliberation. I'll show you cases related to this. Okay?
Yes. Yes.
And any other important thing other than department?
In one of my cases, the department is raising a demand for under section 147, 148 now. And issuing assessment orders. We have told them, you file your claim. Simple as that. To accept, to take it on record. If I have to accept it, I need to go to NCLT if it is to be accepted.
Okay.
That is what is the issue we have.
Okay. But assessment they are doing now.
They are doing assessment. They are passing orders under section 147, 148. All these orders are coming out right now. But when they sent me a demand, they said that there is a demand of this much amount of income tax for various years. They have not filed their claim before the liquidation commencement date. They have not filed it.
Okay.
Now they are sending the orders and they are saying that this much demand is due. We have simply said them, you tell me you file your claim first, then we will discuss about it. That is all we can do that. In order not to, rub the department on the wrong side. You just tell them you file your claim. Then we can discuss about what you said rightly about acceptance of the claim, that the demand should be 2 years before that. The demand should be there. Then we can explain them very categorically. Okay. This is my opinion, sir.
Will it not get hit in provisions of subsection 5 of section 33? Wherein no suit or proceeding, will it not, is it not considered as a proceeding? What are the income tax or department initiating the proceeding? Will it not be barred? Is it not a legal bar under 33(5) to commence any proceeding?
Yes, that is true. But one thing is, they do it and then they send it across. See, as a liquidator, you have every right to tell them that this is what is the proceedings. Now, without a claim, see, there should be a proper claim form from them. Then we can discuss about 33(5). We can tell them that your demand is not within this 2-year period. So we are rejecting your claim. Just by sending a demand notice, we should never entertain them. We should get a claim, then we have to reply to them in a proper manner. That is my sir.
Yeah, they are supposed to give claim only. There cannot be any demand other than claim format, that too within the timeline given under the IBC
liquidation proceedings. Yes, they should have done it. But if they do it right now also, as a humble liquidator, you can very well tell them that you file your claim, then we can give this 33(5) explanation and close the issue out. That will make things very easier for us to, for tomorrow, if they even go to NCLT also, you can very well categorically say, this is attracted under this such and such provision. So we have rejected it.
Many liquidators, I think, affected by that because of the delayed initiation of proceeding by income tax department or GST or whatever department because of the delayed action. I'm saying, I think many liquidators must have got an issue. I think got affected by this issue because of delayed.
Okay. See, normally it is always better that you get the information from the department in a proper claim form, then reply to them in a proper manner. By just sending a demand notice, you don't entertain them at all. You send simply a mail that you file your claim. Simple as that. Then we can explain our situation to them.
In my case, though, income tax had submitted their claim also, and subsequent to submitting claim, they are coming out with fresh liabilities.
That is right.
Then how can I tell them to file claim? I will never encourage them.
No, in my case, they have not filed their claim even.
Yeah, all cases are different, sir.
See, I think they are above constitution, I think. They think they are above constitution.
So true.
What to do, sir? We are dealing with departments, sir. We are not, see, whatever you might say, you are your officer of the court. Do they accept your officer of the court? You are, what to say, liquidator's position is, what to say, more than an RP, more than a resolution professional. He has got every authority. He is, what to say, he is to adjudicate on the, what to say, the claim which is being done. You have to adjudicate. You cannot say that you collate. It is not collate. It is adjudicate. You have to say your claim is accepted, not accepted.
Correct. Yes. Or they have to go on appeal under section 42.
That is what. But no, even that adjudication power which is given to the liquidator, people, do they respect it? That is what is my question. They don't.
Okay. So any other issues? Or anyway, we'll deliberate more on this. I have inputs. I will share you.
Sir, I'm audible?
Yeah, please. Go ahead.
Sir, in our case, dissolution application was filed under section 271, 272 of Companies Act.
Okay.
This was the voluntary liquidation from CD.
Okay.
The NCLT has appointed me as a liquidator.
Okay.
In our sixth meeting, we have concluded to dissolve the company. The resolution was passed. That dissolution application was filed. The I was filed with the NCLT. Later on, three developments happened. One is we got notice from CFO office, SFIO office, that the investigation is going on one of the company, and our corporate dealer I have some transactions with that company. So that was one information. Then there was one claim from one more corporate debtor. The third thing, there was a notice from income tax department.
Okay.
And later on, we have sent one letter to SFI office. We are holding this matter. We are withdrawing. We are holding this dissolution petition.
Okay.
And please inform your developments. And timeline was fixed for 6 months. Now 6 months are already lapsed.
Okay.
So again, we are supposed to send a reminder. This is one thing. Second thing, the income tax notices have come after this filing of the dissolution petition. So there was no crystallized liability as on dissolution date. And third, one claim is received from corporate debtor that was not filed in time. So in this, in summary, there was no assets for disposal. Though there is any liability, company is not in a position to pay any amount. So what is the course of action now, sir?
See, now, okay, let me understand from what you are saying that you are telling that you file in a winding up under section 272 of Companies Act, correct?
Right, sir.
It's not a liquidation because liquidation comes under section 59 of the IBC code.
Yes.
Okay.
IBC code is not applicable.
Yeah, not applicable. So let's clearly understand the difference. So what we are discussing, the point is that not the liquidation, it is a winding up under section 272 of the Companies Act, which you have filed it. And dissolution order, did you get the dissolution order or yet to get?
I was filed for dissolution, but later on we have withdrawn that I.
Why?
We got one notice from CFO office, no? So it there was notice from SFI office.
So we withdrawn the dissolution means of application. We withdrawn the application from the you withdrawn from filing, yeah?
No, we have just hold on that application. The court has passed the order, sine die order. So you got this, whatever you want to comply and come back. So matter is on hold now, sir. And SFI office is not giving NOC. The income tax proceeding is going on. And one more claim is received in between this time.
So my point, see here, what I'm trying to understand here. See, income tax, with respect to income tax, dues and all, there is a provision section 178 on the Income Tax Act. You must be aware of it. Okay.
Correct, sir.
It only exempts the IBC. Okay. it doesn't exempt company winding companies under winding up under Companies Act.
Correct.
Okay, so income tax aspect is clear with respect to winding up under Companies Act, with respect to section 178 under Income Tax Act. Okay, but with respect to other things, there is no that difference is there. So let's try to understand now. Is that all proceedings and all investigation, inspection? If
all proceedings are?
No, I'm just, let me complete. What I'm asking you, I'm trying to, let's deliberate and try to understand. Okay. Is that to dissolve the company, all proceeding, all inspection, all investigation should get over?
Investigation is not for on this company, sir.
Is that a pre-requirement I'm asking?
No, no. This is not the pre-requirement.
So first, my second question, during the company under winding up, can any inspection investigation can be initiated during the company winding up?
The IBC code is not applicable, there is no moratorium.
No, here then Companies Act, there is a moratorium that proceedings could not be initiated in Companies Act. There is an equivalent provision in the Companies Act also. Have you checked?
Under which section?
Have you checked? I remember I've seen there is a moratorium, and otherwise the liquidation will not come to end at all. I will tell you the provision. And I'll see that. I'll verify. I'll check and tell you. But unless you give that moratorium, the liquidation process will not get over at all. Then
True,
liquidation
sir.
will be forever. It will be live forever. Because one department will initiate one proceeding, then next department, another department will initiate some proceeding. Correct? Then there will be a proceedings. There will be a bunch of proceedings will be in work and will be in will be continued. Then when the dissolution will take place, when the liquidation will get end. Okay. And anyway, I'll check and tell you there is a moratorium. I believe somewhere I've seen that. I'll check that particular provision. There is equal provision of how, like section 33, subsection 5 moratorium for liquidation. Similar provision I remember I have seen in the Companies Act. Anyway, I'll let you know that. Okay. But irrespective of that, the proceedings or investigation, inspection, it cannot be initiated during the liquidation period. The reason being, liquidator may not have the complete details. Do you have a complete details?
Sir, this proceeding is investigation is not on this company, sir. It is on group company.
Okay, then what way your company is getting affected?
My company is have some dealing with that company. So that's why they were directed not to dissolve this. Just give me some 6 months time for further investigation.
Okay.
This investigation is on parent company, not on this company.
Okay.
Group
Then
company.
Okay, you can ask very much the stay and restraining, you know, you can seek stay from the court, restraining the proceeding. Section 372, can you see section 372?
Yes.
372 and 373.
Okay.
Just read that 372 and 373. Companies Act, I'm saying.
Right, sir. 372 of Companies Act. Power of court to stay or restrain legal proceeding. But in our case, the court has not taken any decision, sir.
Oh, that's okay.
The order pass is sine die. You decide.
That's why I'm saying there's a power given to the court. Read 373.
Section 373.
Can you read out or you want me to read?
Sir, section 373 of the Companies Act.
379 also.
No, I'm saying 373 of Companies Act, I'm saying. Okay.
Yeah, I will read, sir. Section 373 of Companies Act 2013 deals with staying of suits and other legal proceedings against a company upon passing of winding up order or the appointment of provisional liquidator.
What it mean? What does it mean?
So there is auto stay.
That's why I said there's equivalent provision is there in the Companies Act. Because without this winding up proceeding cannot be carried out by liquidator. See, one thing we have to understand, thing is many people are not understanding, or the world is not understanding, liquidator is not a god. Liquidator is a human being. Okay, and he is a fellow, unfortunately, has done some course, okay, and became eligible to practice it. Unfortunately, many people may be fortunate. Okay, a few may be unfortunate.
Sir, in our case, bench has appointed a professional member who is the ex-NCLT member.
No, whoever it is. Okay.
Is a part of this proceeding. This is a yeah.
Well, all I'm trying to say here, the moratorium provision, what they are here saying, that means section 33, subsection 5 under IBC. Code. Same way section 373 of Companies Act. What the legislator intent only we have to see. The intent of legislator is that once the liquidation order is passed, that should not be disturbed by any of the proceedings. Because liquidator is not the legal counsel of the company to handle the disputes. Liquidator is given a responsibility as provided under the code, as provided under the Companies Act, to receive the claim, okay, to take custody of the assets and receive the claim and freeze the claim. And after freezing the claim and see that he is realizing the asset and distributing it and filing the dissolution. Is it not? Is it not? Then how could this world expect liquidator to step in the shoes of MD and handle all the cases when there is no money in the bank account?
It's a never-ending process.
I'm just asking.
Otherwise, yeah.
Here, the company, the management is obligated to handle the legal matters because they are earning it. They are running the business. They are earning it. And they are doing the business and carrying out the business for the motive of profit. So whatever the dispute, whatever the proceeding, legal proceeding, they are supposed to deal with the proceeding. They are supposed to win or lose the proceeding and move forward. But liquidator is not given that task. The law didn't give that task to liquidator. First of all, we need to understand the department should try to understand that they should not deal with the liquidator just like they are dealing with the managing director of the company. The basic knowledge should be given to the departments. Any government department for this matter, I'm saying. Unfortunately, that information is not getting supplied to any department. The department should not deal with the liquidator as if they are dealing with the management. Management is to run. As you said, after CRP, till the liquidation commencement date, there's a virtual management in the name of RP. Correct? Before CRP, there's a management. After CRP, till liquidation commencement date, there is the temporary or virtual management in the name of RP to manage the affairs. Till then, the department can do all kind of whatever their protocols they want to do. Legally, what they are entitled to do. But not in the liquidation. Liquidator is not. Sometimes I used to get the surprise. And the people who are dealing with the liquidation or the liquidator, rather I should say, not liquidator. People, any person or any department, anybody dealing with liquidator or companies under liquidation, They fail to understand the basic thing. Why this liquidation process, first of all? Why you need to bring the liquidation process, first of all? Because there was a financial failure in the country by corporates, correct? There was a law which provincial insolvency law, presidential insolvency law, and BAFR, all that proved ineffective. Is it not? Is it not?
True, sir.
All that law proved ineffective. Provincial Insolvency Act, Presidential Insolvency Act, BAFR. So what government felt? Okay, let us try to give one consolidated law which really takes care, address financial failure within the timeline. See, here the important thing is that to finish everything by timeline. Because the BAFR and earlier winding up under Companies Act and even insolvency matters under provincial, and this was going for 5 years, 10 years, more than 5-10 years. So government want to stop it. That's why they brought this piece of legislation, that to a code, insolvency bankruptcy code. But how could this code also is made as a one more law? And it's getting, the government and other stakeholders are making it ineffective. This code also they are making ineffective. They are bringing in the list of the all ineffective laws, the code also they are trying to bring it in the same list. Are they? This is only going to happen, correct? You see how many cases are pending today? Let's try to understand. How many cases today is pending? Just to understand, okay, 1,274 liquidations, final report is submitted. Okay. So far, this only has happened. And hardly distribution has took place, very meager. Then what is the purpose of the law then? Why this law, should exist? What is the average time is taken from liquidation commencement date to submission of final report? Almost 900 days, 1,000 days. Average is 1,000 days.
More than that.
Sorry?
More than that.
No, I'm just average, I'm saying average.
Average might be, sir. But
1,000 days at least minimum. It takes minimum 1,000 days. But what law says, what IBC code says to take maximum?
1 year.
No, I'm just saying what it is permitted to complete the process.
It is 1 year. From the date of liquidation, you have to complete the process.
1 year. But how much practically it is taking as per the report I'm saying?
It is taking more than 3 years.
3 years. Then what is the purpose of law then? Then why we need to have this particular law then? What is the use? See, to whose benefit this law is getting practiced? So I think the time has come, then we need to escalate and we need to see that this is reaching the appropriate department and appropriate ears, and the process has to be properly codified to unnecessarily stop all this dramatic proceedings. Correct? Is it not? When the company is already bleeding, one department is coming and doing assessment. What now I can do on that? Is it? They could not have done when the company was active, correct? So that means they can take their own time. But liquidators see that everything is done on time. The timeline is only to liquidator, not to the government departments. So any other issues, difficulties? We will deliberate and we will deliberate many cases on this. Okay, I'll take you through many cases. Any other points? Any other difficulties other than this department, other things? So that once for all, while deliberating, we can discuss all that.
You can start, sir. It is better that you start the...
so that it runs with the flow, right?
Yeah.
Okay. See, actually, my idea was that to make sure you are understanding the basic thing. But Here, the topic is given difficulty. So I thought, what is that? Even you take it for scheme of arrangement, right? Scheme of arrangement is a provision is given today, made part of the law. Is it not? Is it really serving the purpose? Scheme of arrangement. Is it the third part of the liquidation process, or is it the part of CRP, or is it the third phase, or in between intermediate phase? What is that?
Sir, it is the intermediate phase.
Oh, that means it's something introduced between CRP and liquidation.
That is right. Mediation.
Oh, is it
Arrange
really
scheme of-
working? Is it really working?
To my knowledge, no.
So, actually speaking, code doesn't provide anything. Only the regulation provides for, correct? Regulation 2B says that 19 days the scheme has to be completed. But nothing else is there in the code, correct? So, how many cases so far? Any idea? So, compromise arrangement is done. So far, hardly 15 cases or 20 cases. Hardly 15 to 20 cases only. So far, to my knowledge, hardly some 15, maximum 15 to 16 cases only. The liquidation were closed by way of compromise and arrangement. But here, it is specifically provided that as a matter of compulsion, the scheme of arrangement has to be explored. Is it not? Is it the optional or compulsory?
It is.
Is it optional or compulsory? Scheme of arrangement is optional or compulsory?
It's optional only.
So without getting into a scheme, can a liquidator directly initiate the process of liquidation or get into the e-action process without exploring for scheme? Is it? Are you sure? Can we see the? Can we see 2B? You want me to show the 2B? Okay. For your benefits, I'll read regulation 2B. Then you will understand what it is. See, these are the difficulties. What I'm saying, that a liquidator is not really permitted to move on with the responsibility given to him under the code. Is it not? See what 2B says. Where a compromise arrangement is proposed. If there is no proposal, can the liquidator move on directly? Is it so? Or he has to necessarily see that he is exploring. Anyone has handled the scheme during liquidation? After liquidation is ordered? Anyone handled the scheme or concluded the liquidation process by approval of scheme? No. So none of the participants have done scheme during the liquidation process. Is it? Oh God. Good. So when a scheme is proposed, then liquidator should explore it. Okay. But I've seen few matters where liquidator was expected to explore the scheme. Okay. Then there's a few orders I remember I gone through. Okay. Good. Now I'll take you through my slide. Probably then we'll move on to practical difficulties. I wanted to take you through some avoidance transaction. Is there any avoidance transaction that you are dealing with? Or what is the fate of avoidance transaction? I think.
Sir, in my case, avoidance application was assigned to some third party.
Okay, NRRR. Huh?
NRRA.
Okay.
That included PUFE as well.
Okay. So.
But later, what happened was accidentally. I think it's a mistake of registrar at NCLT. It got closed. Actually.
Okay.
And no, the advocate of the assignee, he is actually mentioning the cases, but he is not filed IA to reopen, to close that.
Okay.
To reopen that actually, So because my dissolution application is still pending.
Okay.
So I do not know what needs to be done for that actually, because I am now not the party to that.
Okay.
And I have order which says that it is transferred. It is actually assigned to third party.
Okay.
So,
So
third
now,
party is not taking any action now. So what do we do?
Now it's assigned or not? Means
it's already assigned, and I have order also in my head.
Okay, then why do you have a doubt on that?
No, but only thing is it accidentally or erroneously it got closed at NCLT registrar's end.
Closed means sorry.
Closed means now it is showing closed in NCLT.
No, ordered
disposed of. It is showing disposed of.
Disposed of.
Yes.
Okay, disposed of with what order?
No, order says that it is assigned to third party.
Third party. So that.
But status in NCLT online status it is showing disposed of.
Okay. Did you get the realized money? Realized money?
That everything is over, sir. Dissolution order, the dissolution application was also filed.
Then what is the problem now?
Now problem is that is not because the third party is supposed to act on it.
Okay.
PUFE should not be disposed of. It should be actually heard at NCLT.
Okay.
But now no hearings are happening for that.
Okay.
Although I am not responsible for that but I have been informing the third party assignee to get that reopened, but he is not doing anything on it.
No, then okay.
Someone has to act on it. Otherwise, it will show disposed of.
I know you see. You are clear that you have no role. Means things have to move on its own. Correct.
Actually, I have no role. But bankers to whom I represent, they are losing, no? Because PUFE, because of dissolution application, we assign to a third party. But bankers will be at loss, no? If we do not take action on that. Because in future, if something is realized, it will go 55% to the bankers,
and
45% to the assignee, as per the assignment agreement.
Okay. Okay, fine. So now, anyway, see you.
Sir, my advocate is saying that you file an IA for correcting that error. But how can? Because it will cost me.
Okay. So your advocate want why you are sitting free.
Right. Correct. So what is your suggestion, sir?
No. What I would say that you have to see what is your obligated to do.
Okay, I will just inform the bankers. Actually, I have informed them on email, but they are also silent. They are also silent actually.
What you are legally obligated to do as a liquidator, that you have to do. Okay.
Correct.
So if you have done your duty, then it's up to the court and.
Absolutely right, sir.
Okay. If you are obligated to again take it forward, then you have to involve only. So see what we are obligated only we have to see. We can't overdo also. We can't.
Okay.
What we are obligated. Correct.
Got your point, sir. Well taken. Thank you so much.
See, now let's move on to the liquidation. Just I'll give a brief of liquidation provisions little, not in deep I'm saying. Quickly, I move on the provisions of liquidation, how it works and basic things for the benefit of those probably one or two or few people would not have handled the liquidation process. I'm saying the cases. So for them, for the benefit of them, I think, let me brush up the provision. Basic provisions, then I will move on to the practical aspects again. I will discuss with you matters and cases which got delivered or ordered NCLT, and other courts. I'm saying for again government departments and other matters. We will deliberate much in detail. But before that, let's try to understand what are the situation the liquidation comes, because the basic things is liquidation. What are the cases? The liquidation comes. One, COC decides to liquidate. Correct. COC first either to decide to liquidate it. In that situation, the liquidation takes place. The second situation, adjudicating authority should not get any resolution plan for approval. So in that case, probably some 600 odd case it happened. Okay. So in that cases also the liquidation takes place. Same way, COC, I believe some nearly 2000 cases, COC decided to liquidation. So far I'm saying. Okay. So, and same, the another situation, third situation, adjudicating authority rejected the resolution plan for non-compliance. Some 60 cases and now is reported that adjudicating authority rejected the resolution plan. Owing to that, it gone into liquidation. Okay. Then after approval of resolution plan, okay, then corporate debtor contravenes, the resolution applicant contravenes in implementing the resolution plan. Then also again it goes back to the situation and again it get into the liquidation process. With that, some 30 cases I have reported as of now. Okay. So this is the basic numbers which so far, COC itself decided to do some 1,900 cases I told. And AA did not receive plan for about 608, 80 cases something. And AA rejected some 60 and odd. And resolution applicant contravened about 30 cases. So these are the numbers till date I'm saying. Till date almost, till date or maybe little more than these numbers. Okay. So, but if you see as on end of 2024, so almost 71% of cases liquidation was ordered on account of COC decided to liquidate the CD. Okay. But as I was telling that the average time was taken about 900 days, nearly 900 to 1000 days. That was the average time taken. Same way for voluntary liquidation, nearly about 350 to 400 days is taken. And even some cases, a dissolution order for took 900 cases, 900 days. In some cases, it is reported. So these are the basic numbers, how it works. Okay, let's try to see what is the liquidator role. Then probably we'll go into the difficulties then. Liquidator to make public announcement for submission of claim under regulation 14. Then liquidator to receive and collect the claim of the creditor within 30 days from date of commencement of liquidation process under section 38. Then what is the next process? Liquidator to verify, he has to verify the claim in 30 days time from the last date of receipt of the claim. He may either accept or reject the claim within 15 days of last date of the receipt of the claim. So this is what the powers given to the liquidator. See, there's a difference between the powers and duties. Please understand. We need to understand the powers and duties because it has got a lot more to understand. That's why I'm very specifically telling. Even many of my cases, we have deliberated, argued in the matters before the court. The powers is different and duties are different. Okay. So here the problem is the duties and powers are getting mixed up in cases of in the matter of liquidator and liquidation. That's why it creates lots of problems. Because people takes advantage against liquidator by mixing up both. Okay. Let's try to be clear. Okay, what is our power? What is our duties? What is our responsibilities? Okay. Now, liquidator, not only that, as I said, within 15 days from last date of receipt of claim, he has to either accept or reject. Okay. Then he has to verify the claim, whatever collected. Suppose during CRP, somebody would have submitted the claim and in liquidation, someone would not have submitted the claim. Then in which case, the liquidator has to see, he is verifying the claim collected during CRP in 30 days from last same 30 days time of last receipt of time. So these are the things that, as a liquidator, one should have a timeline in mind to see that he is making it proper and following it properly. Then after this communication of this acceptance or rejection of these claim, the creditor may file an application before NCLT against decision of liquidator within 14 days under section 42. This is the provision related to the claim, I'm just saying. Okay. Here, what are the difficulties? What are the way out in all this what we have discussed? the power is not given to the liquidator. Okay, the power is given only to verify the claim and adjudicate the claim. He can't, suppose one of our friend has said the department has given, government department has given claim now. Liquidator do not have power to condone, then how he can take the claim? So all these matters are before argument before the courts, and still matters are before the court, and few got ordered also. We'll deliberate more in that aspects. Then in which case what happened? Whoever the creditor, he has to approach the NCLT only. NCLT liquidator, it's not a duty of the responsibility or power of the liquidator that he can approach the court. Only the creditor has to approach. Okay. And government dues and whatever the dues that you know that recently a chairperson has given a communication. I don't know how many of you have seen the communication rainbow cases. Have you seen the communications of the chairperson on rainbow case? Anybody have seen recently? Any idea?
No.
Some chairman has shared one thing. Anyway, I'll see whether I can show it to you. The recent thing what the chairman of NCLT has shared. With regard to rainbow, that rainbow matter should not be taken as a precedent. Okay. Of course, there's another case is there. Anyway, we'll discuss all that going forward. Okay. Now, what I was discussing. Just a moment. Yeah. So what happens? Suppose the claim is not given during the that means when the company is in the liquidation, the claim is not given by the creditor. In which case, will that right be extinguished? No. Whatever the claim given in the CRP period, that has to be taken, considered by the liquidator. All that you must be knowing that the provision got changed, and it becomes a duty of the liquidator to make sure to verify whether the claim is given during the CRP by the person, by the creditor. Okay, the same person who has not submitted the claim before liquidator during liquidation process. That's we need to check. That as a liquidator, we need to check all that. So we need to see that the claim at the time of commencement, whatever given at during the CRP, it can be updated. In fact, the provision permits to update the claim. In case the claim is not given during the liquidation, then whatever the claim given in the CRP can be taken as it is. Otherwise, the claimant can update the claim and give during the liquidation. This is how, with respect to the claim. So let's now come into the very important thing on the liquidation. This thing, the workman employee, and anybody has faced issue on this workman employee? Yeah, I need to deliberate few points on this. So after knowing from you, anyone has matters before the court on workman employee pending dues or any cases are filed by department?
Sir, in my case itself,
yeah,
we had one IA from employee, which was dismissed by the Mumbai bench. Okay. Because as a liquidator, I rejected their claim with respect to interest and TDS.
Okay.
So they went to, and they all actually, despite my paying provident fund money, they went to the NCLT complaining that not even provident fund money was paid, because they have not realized provident fund money. I have paid to the department.
Okay.
So they filed a case which was dismissed by NCLT recently only.
See, I think I heard even in my last deliberation also many participants have raised this concern that PF department and the ESA department, all that department are putting interest penalty, even for the entire period, during the CRP, including CRP period, and they are putting blindly the interest and penalties, and even though there is no fund in the company, means contribution made by the.
Correct, sir. Correct.
Okay, so I think anybody have that issue, or anybody have got any order in that issue, so that would be useful to everyone. So far, anyone has got any order on this? No. See, actually speaking, workman dues, you all must be knowing that it has the same meaning as it assigned under section 326 of the Companies Act. Workman dues, whatever the meaning assigned under 326 of the Companies Act 2013, same, it has got same meaning. Okay. So what it is that what are the money due to the workman from Provident Fund, Pension Fund, gratuity fund, and any other fund, whatever they with respect to the welfare of the workman, maintained by the company. Okay. So what happens if any shortfall? If suppose any shortfall in liquidation by after realizing liquidation estate, we are not able to contribute, then what will happen? Will the liquidator is responsible or is it liable? The liquidator is liable for that if it's not able to compensate, or is it to be kept outside of the liquidation estate? What is the difference between these two? Any idea? Whether PF dues forming part of the liquidation estate or not? Let's try to understand this. Any idea? No. There are many dimensions on this. That's why I'm asking. That means any compensation can be given on PF dues or whatever ESA dues outside the section 53 only. I'm asking. Is it permitted? Let's see. Try to find answer to all this.
Sir, PF, this is Bhuvaneshwari. Good afternoon to you. See, if there is any, let us say, fund created for the with respect to the PF, PF contribution, that cannot be part of the liquidation estate. It is meant for the employees only.
Yes.
However, in the liability, if there is no fund created but the liability is pending, that is coming under section 53, and that has to be met like workers' dues or employees' dues in priority.
Okay. The liability. Okay. Can you, ma'am, can you clarify how the liability arises when there is no contribution from company?
Sometimes they have not created a separate fund with LIC or with anything, but they keep paying directly to the government, and for few months or few years they have not paid the dues.
Okay.
And hence the liability has arisen. In that case, they have to settle that liability, whatever is claimed by the PF department.
Oh, here, actually speaking, that's what even earlier session also when I was addressing, the same discussion was going on. 43, what it exactly says? It says only the voluntary or statutory contribution. Or what it deals with. If the company has, see, what the provisions of section 36 want us to exclude, that we need to understand. What exactly 36 want us to exclude? We will try to understand so that it will be easy for us to. I will show you that all some, it says the following shall not be. I'm reading out 36(4), section 36 of section 4. The following shall not be included in the liquidation estate and shall not be used for recovery in the liquidation. That's what the section 36 subsection 4. In that, all sums due to any workman or employee from Provident Fund, Pension Fund, Gratuity Fund. This is what the exact language used. All sum due to any workman, employee from the Provident Fund, from Pension Fund, from Gratuity Fund. What does it mean? What exactly it means?
So
from Provident Fund, yeah.
So if there are 10 lakhs in the Provident Fund account, and let us say somebody is claiming out of that 2 lakhs, 2 employees have retired, and
no, that's why I'm asking this. You said no 10 lakhs in the Provident Fund account.
Yes, yes.
It is reflected in the financial statement of CD or not?
In the CD, it will be reflected.
Is it voluntary or statutory?
It's statutory.
Statutory. That means, okay, it refers only the statutory, not the voluntary.
See, even if it is whether it is voluntary or statutory, in my view,
it has got a lot of difference between both.
In my view, once it goes into the PF account,
okay,
and it cannot be used as part of liquidation estate.
Yeah, that's okay. I understand. See, as long as it is named, colored as a provident fund, it cannot be used. I agree.
Yes.
I'm asking the management, is it obligated? See, my question is very simple. We are trying to understand because these things are still open only, still under deliberation only. I'm saying it's not come to the conclusion at all. Suppose the management has not contributed voluntarily towards provident fund. My question is that liquidator is responsible for that also, and my question is that only.
Sir, yeah, what happens, in fact, I have worked in organizations calculating payroll also in finance department, so I know. So as part of a payroll of a particular employee, if it is part of the package, payroll package, salary package, whether it is voluntary or statutory, it has to go to the government. It is meant for the employee.
No, I agree. See, here, that's why I'm saying. That's why I wanted to be very specific on the word what I'm using. I'm saying whether it is voluntary or statutory, as long as it is find place in the books of the company, it has to go. No doubt at all. It has to go to the employees. There is no denial at all. There is no second thought on that. As long as it is reflected. My question here, suppose the company has not contributed voluntarily, then liquidator is liable for that voluntary contribution also to make sure that he is making payment to the workman.
Exactly. He is liable because it's due to the employees. And it was supposed to have gone to the government. The CD has not paid to the government. He has to pay.
Suppose the company does not have a scheme of voluntary contribution, then?
Sir, as long as it is not part of the payroll, the employee, when he had a lot of money, he was voluntarily contributing. When he does not have money, he didn't contribute.
That's why I'm saying here. This only people are taking advantage. The government is saying, no, departments are taking advantage in dealing with the liquidator. See here, the confusion is here only. Okay, the Companies Act provide and gives, I won't say even obligation. It gives a option to the company to voluntarily contribute. Okay, the Companies Act only give option. Companies Act does not mandatorily gives an obligation to the management to give voluntary.
Sir, can I tell you something?
Yeah.
No company does voluntarily. It is part of our payroll package. They say in the payroll calculation, each column, how much care it goes, whether it is paid to the employee or to the government. In that, the voluntary contribution comes in the table of calculation. So company is a business entity, just like that, without even showing us the employees' dues, nobody contributes to the government. Let us be very clear.
See, I have handled the matters companies, madam, in that they will not deposit at all. They will have a voluntary. They have voluntarily, they will have a fund in the company itself.
Okay.
The balance sheet will have a voluntary fund of the provident fund.
Okay.
It will not have gone to the department at all.
Okay.
Because,
sir,
yeah, tell me.
Sir, one more point. If this fund is managed by trust, and if there is a shortfall in the trust account or towards the contribution by the employer, in that scenario also, this is the responsibility of the resolution professional.
See,
PF fund is managed independently under trust.
Okay.
And if there is a
what on behalf of what?
On behalf of employees. Employees.
Okay.
Say PF contribution.
Okay. Oh, and some trust is created. Okay. What you
saying? If the as per calculation 100 rupees is payable, but company has deposited only 70 rupees.
Okay.
So that shortfall is the liable responsibility of the resolution.
The trust, what you have called, is statutory or voluntary?
Is managed by employees and representative of management, representative of employees.
The problem is that see, this is where we are facing the problem. Here is it, we need to stick on whether it is voluntary or statutory. Then only accordingly we can deal with that. Because since we are putting everything in one basket, no, there only the confusion arises. Because I'm seeing many of the matters in workman dues. I'm seeing the deliberations, I'm seeing the orders. Nowhere that clarity is getting given where it is voluntary or statutory. Because the Companies Act gives option to the management to have a voluntary fund also.
The PF is a statutory liability, sir.
No, that is there. That see, statutory, there's no question at all.
But it is managed by trust.
Exactly, what I'm saying, when it is a statutory, there is no question at all on
okay.
That need not be deliberated, what I'm saying. Because, why? Because when it is a statutory, the law says, even section 36 says, even IBC code confirms, even Companies Act confirms, that the moment it becomes statutory, it is not fund of the CD, it is a money of belonging to the employee.
True.
Okay, the law is very clear.
Yes, yes.
Statutory part, we are not at all negotiating, we are not at all disputing, or we are not at all interpreting anything on statutory side. We are only discussing, because every now and or then I'm seeing the orders, they are mixing up both voluntary and statutory. And unnecessarily the confusion is getting created, and unnecessarily liquidator are pulled to answer the questions, or our department is unnecessarily making the liquidator to face the music. In fact, we need to deliberate this as a separate session. Then only I can much deliberate more in deep of this. And specifically, I can deal with that. What is workman due? What is EPF contribution, and how it is dealt with on the Companies Act, how it dealt with the IBC? What is the role of liquidator on that? And what are the, so far orders are passed with the court on that, right? There are many orders have come. Now it's settled, but still clarity has not emerged. But we are still now, as of now, what we are understanding, we are going by section 36, and as I told you, subsection 4 and class 3, where it excludes. So it is not a liquidation estate. My point here, those would have handled earlier the voluntary contribution to PF, ESA, they can easily understand that how they can make difference between the statutory and voluntary. Anyway, since I opened up that, suppose I can get some input on this. That's why I opened this topic. Yeah, these are the issues really faced by every liquidator, I'm saying, before distribution. What is the sum due? It is reflected in the CD, there's no doubt at all. Because after it comes from management to the books of the CD, whether it is a voluntary or statutory, it has to go to the employees, no doubt at all. Question here, if management fails to contribute, statutory, then also it is mandatory. Voluntary, then there is no answer for that. Anyway, good, we'll have a session for this, don't worry, and our institute will organize, and we need to have much more clarity on this, because everyone has got a different perception on this. This with respect to the employees, workman employee benefits. Let's try to understand as of now what 36.4 says. We'll try to understand, okay, whatever the fund in the books, it has to go to the employees. It cannot be forming part of the liquidation estate. That's all. So here, why I ask this, is it possible to treat such voluntary fund as being held in trust under section 36.4A1? This only I was trying to find answer, but anyway, we need to much deliberate for that. Okay, right. Now, adding to this, what I'm trying to say, even this alchemist matter in long back in NCLT also made clear, pension fund, provident fund, charge fund cannot be recovered, by section 53 code, because it's very clear. It is well settled in NCLT in alchemist asset restriction matter versus Moser Beer matter itself. In fact, the same was upheld by NCLAT also in the Moser Beer matter. So it is settled. So not much different, but the difference has not really come out between the voluntary and statutory. Even in the matter of Savan Gudiwala matters also, the same thing was addressed. If the corporate debtor has not created a fund for PF gratuity, then the liquidator is not under any obligation to provide for the same. This was the verdict has come in Chavan Gudiwala by NCLAT, Honorable NCLAT. So that only I am trying to find a difference. There's a very minor difference between both. But in that matter, it was deliberated. Okay, this is asset reconstruction. What I was saying, Chavan Gudiwala versus Apala School. Okay, even same thing was dealt with the asset reconstruction company with the precision fasteners. Also, the same was dealt with, wherein it was said that no, if CD has not created fund for PF gratuity, this only I was asking. There is no fund created for PF and gratuity by CD, then liquidator is not under obligation to provide for the same. When it is statutory, the CD has to create. There is no doubt at all. Okay. If it is a voluntary, CD need not. And in that ground, liquidator should not be made liable. That's why that case, the final order has been passed clarifying the liquidator is not under any obligation to provide for the same. If CD has not created a fund for PF gratuity. Same way, if you see EPF dues, it to be paid in full, calculated till insolvency commencement date, along with whatever the damage levied. Okay. But only thing is, they do not form part of the asset of the corporator by virtue of, as I was saying, section 36 and section 18. Even this matter, this particular context dealt with by Honorable NCLAT in Tourism Financial Corporation matter. This is Rainbow paper. So same, that's why every matters, if you read each and every provision, we can understand there's a slight difference between each and every cases. Even if a resolution plan is approved, does not provide for the payment of unpaid provident fund and gratuity to the workman, the same has to be paid by the resolution, successful resolution applicant. This is what it has been held by Honorable NCLAT in jet aircraft maintenance matter. So in every cases, if you see, there's a subtle difference in each, in each and every matters which we need to understand. Even I was telling you the tax due matters also. In fact, if you see, secured creditors has been defined. All you know that section 30, subsection class 30, section 3 and class 30. Okay. So now in Sundarshan Bhatt case, it is very the matter the means it has been made clear by Honorable Supreme Court that IBC has an overriding power than the custom. You must have all seen that. So same thing only for any government matter, as long as it is not excluded or it is not affecting the privilege that is given to the PFAS department under section 36(4). Same way in Leo edible oil also. Andhra High Court as they ruled with respect to that income tax matter, they cannot be equated to the secured creditor. So there's many more cases are there to deliberate on this. In fact, I'll take you to much more tax cases which I said. Though the rainbow matter which I was deliberating, rainbow matter, which the Honorable Supreme Court went on to say in the rainbow matter that secured interest created by virtue of that Gujarat VAT, the state has secured creditor as per definition. But subsequently, you all know in Pashchim Mahal, you must be Vidyot Vikram Niyam case, Raman Investment matter. It has been we have to say clarified only, not overruled. It is clarified. They simply clarified that no, the matter is different from rainbow is different and this is different. So they simply held that that in the absence of a specific provision or enumeration in the government dues, no section. I was referring that only in section 53(1)(e), that matter only. Said to be treated, but the treatment of amount payable to the secured creditor and dues payable to government, both are different. We need to understand difference between the government and secured creditor. So rainbow matter has not be settled. After that, it has been clarified by subsequent matter. Even recently, our Honorable Chairman has clarified. I'll show you before end of this session what is the clarification all about. So now these are the specific things which I thought, before getting into other deliberations or other points, I thought I can, to deliberate. Same way with respect to SEC constitution. Is there any issues faced in SEC constitution in liquidation? Probably we will go into that because lot of issues are faced by practically many liquidators are facing difficulties in handling SEC matters are to not formulation, probably formulation little difficult. They after taking struggle they are formulating it, but after approval. Here, is it a consultation with the SEC committee is a mandatory or directory? Can anyone clarify this point? Is that SEC consultation?
It's mandatory. It's mandatory.
Is it mandatory?
Mandatory. SEC has to be mandatorily formed.
No, that form is different. I'm asking consultation only. I'm asking forming not. I'm not asking forming. Forming is mandatory, no doubt. 31A makes it mandatory regulation.
Now it is mandatory. Consultation is also mandatory now.
Is it so?
Yes.
So, madam,
consultation mandatory, but what they are giving, it is not.
No.
It's only advisory.
No, madam. Just you are diluting. That's why I'm asking. The problem is this only actually. So, problem is, see, as a liquidator, when we fail to pinpoint the lacuna in the legal provision, nobody else will do. Because nobody else will come and fight for support for liquidator, I'll tell you. Only liquidator has to fight and support for liquidators. No one will come. Everybody were very much waiting to find fault on liquidator, not to appreciate liquidator, right? I think I'm just talking to your mind voice. I'm not telling my views. Okay, why this point, a particular point I raised? I'll take you through 31A and madam also said advisory, all that. But why specifically this point I raised? If you go and see section 33, in fact, I want to show also, I want each one of you to go through section 33 word by word. I'll show you also. But before that, in this context, SEC context, I wanted to tell only one point. Section 35, sorry, 33, 35, I'm saying powers and duties. Okay. In that section 35, why particularly this particular point I want to deliberate? Because the lot of hue and cries with respect to stakeholder consultation committee matters, written matters. And almost they are slowly, like our MCA, initially they introduced CSR as a voluntary, CSR as a, just to help the society, environment, all that they were keep telling. They slowly they introduced, they brought as part of the reform they brought, then as part of the provision voluntary they brought, then now they made it mandatory. Now they are levying penalty for that. Because, see, something which is just brought as a matter of consideration for the corporate to contribute, now it becomes that if the corporate fails, it becomes offense now and penalties are getting levied for not contribution of CSR. But the days have gone when it was voluntary. It was just injected just as voluntary. Same way, the stakeholder concept committee, it was injected initially, okay, just we will bring a stakeholder committee. We will say that it is only an optional or it's only a kind of a advisory only and liquidator need not to do. Today the SEC committee is given power to remove the liquidator. Is it not? See here, we are telling the SEC what are the advices given by SEC is only an advisory in nature. It's not mandatory. But SEC is given a power to remove liquidator. That also advisory in nature? Advisory to whom? That advices is to whom? To remove liquidator. That power is given today or not? Given power today or not? You have to open your mouth.
Yes. SEC can remove the.
One side we are see problem with all of us is that only. Everyone wants to play a safe game. Everyone wants to save their skin. I'm saying not everyone means not liquidator, I'm saying. Liquidator trying to save the skin to see that unnecessary things should not come to them. Okay, but I'm saying government and everybody want to save the skin. Irrespective of their position, they want to save the skin. They don't bother about anything. They want to save the skin. Whether mandatory or statutory, they have a power or not, they want to save the skin. Slowly they brought SEC. They give slowly powers. Though always they are equated to the COC today. See, what I'm asking, when the suggestions or whatever the recommendation of SEC is only in advisory nature, can the power given to the SEC to remove liquidator? I'm just asking. You all liquidators only, no? Please share your view. Just share your view. The power today is given to SEC to remove the liquidator, is it not? Please go and read section 35, subsection 2. Section 35, subsection 2. It is not amended in IBC. It's still there in the code. Okay. It says it gives the powers and duties of liquidator in section 35, subsection 1. It has have a class from A to N or A to O to perform any other function as maybe the board. It is O. So in subsection 1, class A to O, powers, duties. Subject to the direction of AA, liquidator shall have following powers and duties. Please understand, this is powers and duties. So both is given to the liquidator from class A to N under section 35, subsection 1. So here, please underline and bold it, powers and duties to the liquidator. Okay. So liquidator has got a power and also is duty bound to do that under subsection 1. Please see subsection 2 of section 35. Subsection 2 says the liquidator shall have power to consult. Power to consult any of the stakeholders entitled to a distribution process under section 53, provided that such consideration shall not be binding on the liquidator. That means liquidator, the statute, the code, keep the liquidator in a higher foot. But today, how it got diluted? If the stakeholder committee want to throw the liquidator, they can throw out the liquidator. Is it the intention of legislation? Then the act subsection 2 has to be amended. Is it not? Am I right or wrong? Otherwise, I will also keep quiet like you. I will pass on to next topic. Let's struggle with the SEC provision, compliance of SEC provision. And let us accept they are supreme. They will decide which liquidator they want. Is it? So that means what is the relevance and what is the significance of subsection 2 of section 35?
Sir, my humble view is that as a creditor, they have the right to propose and propose a liquidator and get the liquidator appointed. However, the fake creditors, at the same time, if they are not happy with the creditor, liquidator, they have the right to throw out that person.
Means, I'll tell you,
however, let me finish, sir. Yeah. However, once the liquidator is appointed by the court, it is the duty of the liquidator to follow the law. So if SEC is advisory or mandatory, that we are supposed to see. However, our initial appointment, let them change the liquidator. But as long as I am the liquidator, I will follow the law, which is advisory. Their SEC, whatever they say is advisory, I will follow. Take it as advisory. If it is not in line with my thinking, I will make my remarks very clear in the minutes and move forward.
You finished, ma'am?
Yes, thank you.
See, ma'am, when the law says that liquidator shall have a power, it will not bind the liquidator. So I'm saying the code. The code says, not regulation. It's an act. The code itself says liquidator shall have a power to consult. Okay. He may consult, he may not consult. Okay. Then any consultation shall not be binding. That means they want to keep, the law want to keep, the code want to keep the stakeholders is not dominating or is not compelling liquidator. That's what the intention of the code. I don't want to understand general way. Okay. I am not here just to say that, okay, like a dictionary, let me also read the law and let me just follow whatever the law. I want to do as a liquidator in letter and spirit what exactly the legislative intent in bringing this particular portion of law. So I'm just trying to open it for deliberation only. Okay. Here the code specifically gives power to the liquidator to consult. So if liquidator want, you please consult with the stakeholder. Even if you form a committee, of course, I know it is mandatory, 31A makes it mandatory, all that is there. No doubt at all. Then too, the principal act code gives liquidator the power to consult, and that is not binding to the liquidator. The code itself clarifies. So my point here, my understanding, probably humble understanding here, is that when I am given a power to consult, I may or may not consult with them. And sometime if they give some inputs to me, I may not accept their inputs or suggestions because it is not binding me. Naturally, the SEC or stakeholders will be unhappy and they will be removing me only. No. One side, law is giving a power to liquidator and also gives power stating that or gives the legal authority that it is not binding, you have to follow. You take their consultation, but it is not binding you. As a liquidator, as an independent person, as an officer of the court, you follow which is right. Don't get biased by anybody. That's what the code intention. That's what the purpose of the code, which it sounds in 35(2). Because liquidator is appointed by the court. He is a representative of the court as an officer. So you should not get influenced by the outside person. That was the probably my humble understanding by the legislature that liquidator should be independent, should not be influenced by stakeholder. That's why the law went on to say that if you have power to consult stakeholder for your inputs, at the same time, it won't be binding you. You take independent decision because you are the officer in court. You are representing the court. You should not get biased. You should not be forced by some outsider for their benefit or for any purpose. So that's how I understand that. Today, one side of law is like giving a food one side on the plate, other side taping our mouth. Okay, you take food. What is the use of food? Anyway, your mouth is put zip, taped. You can't take. Here the code gives power to the liquidator. Take inputs, but don't get influenced. But here, other side, when stakeholder is not happy, let them change. I'm saying I also respect the law provision. They want to change, let them change. All I'm saying, is that the intention of the law only I'm asking. But that doesn't sound to me, according to me, when I read it, subsection 2 of section 35. Because it gives power to the liquidator to consult, and at the same time, the lawmakers are very careful that the liquidator should not get influenced, should not get coerced or forced by the stakeholder to follow whatever they say. That's why they went on to say that it is not binding. Naturally, when the liquidator is not going to listen or take up the suggestions as an independent officer of the court, the SEC is going to be unhappy only, they are going to change. If you are accepting, we have to accept only. If the court changes, let them change. We'll again see it after 10 minutes break. Thank you. Thank you, everyone. We'll see. I'll take you with much more details after 10 minutes.
Hello. Hello. Meeting is going on or completed?
Hello? No. It is only break. 10 minutes break. We'll again deliberate after 10 minutes.
Okay.
Okay. Coming back to session. So now I will share my screen so that I can show you a few things. Okay. Now, in continuation of our discussion before just wanted to take you through one provision, then we'll move on to next. This is the latest provision of 31. Okay. Continuing our deliberation that stakeholder consultation committee. I think stopping. Now let's see one important thing is this. I wanted to show you. That's why in fact, the provision provides. Who is talking? Okay. Now, if you see same regulation 31A, what I told in section 35, in fact, that also is coming only, but still the advice on consultation committees shall not be binding on the liquidator. Okay. But only thing is with the rider that the liquidator takes a decision different from the advice shall record the reason for the same in writing. Okay. Now I'll be moving on because I have to cover more. So if any doubts or any points you want to, then you can stop me and tell me so that we can move on. So with the left out time, whatever I can try to deliberate more points, I will try to do that. So I'll quickly move on. So if anything you want, you can stop me in between. See here, the subsection 10 talks about advice of the Commission 7 same thing which is there in the Act. I was telling section, I'll show you the Act also. This only I was referring to you to see. Section 35 talks about powers and liquidators. Subject to action of waiver, liquidators shall have following powers and duties. Okay. Now, subsection 2, I was referring this. They have power to consult. This only I was deliberating before our break. But such a consultation shall not be binding. This only the regulation also confirms. Okay. Now I showed you the regulation that also confirms that it is not binding. Okay. But this only I was trying to tell you that the consultant after recording the reason may by majority not less than 66% propose to replace liquidator and file an application after obtaining consent. So they can replace the liquidator. See, one thing is here it is not binding. But if you don't listen to SEC, SEC is given a power to replace the liquidator. Okay. So this is what the I see it as a contradictory thing because one side it is one, otherwise it should be made as a mandatory, the liquidator will follow it. and there won't be unpleasant situation to the SEC also. So when that power is given, that it is not binding, that liquidator naturally will go on his own decision after recording the reason, after complying the requirement of reporting the same in the, there's a rider that suppose he shall record the reason if he is not following and submit to such decision to the adjudicating authority and to the board. So there's a provision in place has been brought in. So liquidator can follow according to that. Fine. Now, why I wanted to show this, I wanted to show you the...
Sir, no voice.
No voice. Oh God. No. You're not getting my voice? You're not getting my voice?
Sir, you are audible, sir.
Yeah, then how could... see, my audio is on only, okay? I think you have to check yours. Fine. Now, moving on to Act, I wanted to show you one important thing. The challenges, though we are facing, here you see what are the powers given, duties given to the liquidator. In spite of all that, liquidator is facing difficulties. These are the powers given. What are the powers? To verify claim, to take into custody of control of all assets, to take what are the measures to be taken, to carry on the business for beneficial liquidation, and to sell the immovable properties. So only these power is given, powers and duties given. Why I wanted to show, is there any power given to handle, of course, here it says, I told you, no, that 33 says that proceeding can be, I will show you 33 for that matter. See, subject to section 32, where a liquidation order has been passed, no order legal proceeding shall be instituted by or against a corporate debtor, provided that a suit or other legal proceeding may be initiated by a liquidator on behalf of CD with the approval of AA. So this is given. That means maybe instituted only. It is an option given to the. I have to rather say it is only an option given to the liquidator to initiate. Whereas at the same time, we see the subsection 5, the liquidator has been passed, no suit or other legal proceeding shall be instituted by or against the corporate debtor. Because for recovery purpose, any department, if they do assessment, which our friend in the beginning of the session, it was raised point, I want to connect to that. Okay. So in case of any recovery, there cannot be any fresh proceeding at all. Okay, by the income tax for recovery, unless except for giving a claim to the liquidator. That also there is a statutory timeline within which they are supposed to give a claim to the liquidator. Okay, within 30 days of liquidation commencement date. So now going by this, now if you see that the powers and duties, it only gives the obligation or powers or duties, rather obligation, I mean to say the duties. The section 35 only gives the duties to the liquidator to verify the claim, to take into custody of control of the asset, evaluate the asset, and they take measures to protect and preserve, and carry on the business for the beneficial liquidation only. Then too, it is for beneficial liquidation, not to run the company and earn profit. Okay. And to sell the movable immovable property by auction and with the power to transfer. Okay. And to draw, make, endorse, all that routine thing for realization. After realization, you need to have a power to deal with the fund. So all this power is given. To obtain any professional assistance from any person or appoint any professional in discharge of his duties. So to appoint any professional, that power is given in the Act. In fact, and the same thing as even in a liquidation order, on adjudicating authority directs liquidator that he can appoint professional to carry out the liquidation process. So, in discharge of his duties, all that is there. So that means the power appointing a professional is given. Now, if you see here, unfortunately in SEC, we need to take their concurrence. for that. So see, nothing but the same replica of COC in CARP, they're trying to bring SEC almost equivalent to the, that means how like an RP under the guidance and supervision of the COC, they are trying to bring the SEC, and the liquidator will be under guidance and supervision of SEC. This is going to be the future, probably maybe requirement, and may come in future, that how like RP was conducting the proceeding of CARP under supervision guidance of COC. Same way liquidator is expected. That's only. Here, if you see the professionals, the language what is used here, the liquidator shall constitute to advise him on the matter relating to. So that means whatever the power given to the liquidator here, it is restricted here. Of course, advice has to be taken. Suppose one particular professional liquidator want to engage, they need to get blessing of SEC. Is it not? So here only I am saying there's a, of course, liquidator should not be given a free hand. That's the intention. But if you see, the liquidator is a court officer. One thing what we are forgetting, liquidator is not independent. Liquidator is obligated to report everything to the court, and the liquidator is obligated to justify his action to the court, because he is representing the court, is a court officer. Then too, he need to go and advise of the creditors, that means in the form of SEC. So suppose the liquidator take a decision, no, I want to engage this particular professional or particular service, then too, he has to take the advice. And now, of course, the provision has introduced that if he is not following the advice, then it has to be reported. See, you see the process, how it goes. So, liquidator is not given a free hand to appoint professional. Same way is not given free hand even in many matters, in sale, all that. He has to see that he has to necessarily see that he has to consult stakeholder committee and take their inputs, see the guideline, follow the time limit, and do everything on time. And getting advice from SEC also should happen by time. Then only the liquidator can execute all the whatever the duties that he has to execute under 33, 35. He has to execute by time. It is not open. Within 1 year, everything has to complete. Our friend has already confirmed now. Within 1 year, the liquidation has to be completed as per the statute. So the liquidator makes sure that he is taking advice of the SEC, and accordingly is doing it. If he is not following it, and he has to write to the adjudicating authority and IBBA why he is not following as per this subsection 10. So this is, I'm just saying, I'm trying to see that Act is giving some power and duties, and the regulation is giving. Of course, they are trying to see that how the activities or duties or whatever, however, this manner, the style, the liquidator is conducting they want to streamline it, no doubt at all. But one hand, court is directing liquidator to execute certain things. The other hand, the liquidator is expected to take advice of the SEC and do it everything on time. And taking advice also on time, he has to make sure somehow he takes that advice by time. Then only he can. Okay, now in this power, what I was showing, proceeding I showed you 33, fine. In that, is there any obligation given to the liquidator to give details to assessment and to give complete extent support to the assessment, or whatever the new proceeding is initiated by the department, any government department? Is there any duty and power is given here? Any duty is given, leave it all, the power won't be there. Is there any duty is given? I think my dear friend who started about assessment, the starting of the session. Sir, here can you see whether liquidator has got any duty here to completely support the assessment whenever it is initiated after liquidation or during the liquidation? Is it the power is given and duty is given to the liquidator? No, otherwise under which power and the liquidator is obligated to provide all the details to the government department who are initiating any proceeding. Any department for this matter, I'm saying. Any department. I'm not telling only income tax, GST or any department. Suppose they initiate any proceeding, any where the liquidator derives the power and where he is duty obligated to support and make sure that everything is properly given. Except this provision, any other provision is there? The participant, almost 40 participant is there. Can you tell me that anywhere else, any power is given or duty is given to the liquidator to handle all the proceedings, I'm saying, except 33. 33 I showed you. No fresh proceeding can be initiated. So all that now today the government department is expecting liquidator is to support for the proceeding what they initiated. Correct? Is it not? Is there anything is given here? Can you tell me, or at least let's have some points. Is there any obligation given to the liquidator here? I don't find. If you find anything, you can tell me. Let me know. So I'll try to follow. I'll observe the provisions, comply the provisions. Okay. Here it doesn't say anything that the liquidator has to give. Okay. This only I want to show you. So that means your assessment, whatever the assessment or whatever reply given by liquidator, first of all, is liquidator is duty obligated to give detail. And first of all, he should have a detail to give. Suppose he is not having a detail, the income tax department will do best assessment. They'll pass order under best judgment, right? 144, right? And they quantify some amount as a due, tax due. Because liquidator is not having a detail, no? How the liquidator can give a detail when the detail is not shared by the promoters or CD? In which case, income tax is given a power under income tax under 144, go by the best judgment and quantify the due amount, tax due amount. Not only tax due amount, they also put the interest, they also put penalty for that. 50 crores tax due, they demand 150 crores. Problem here is where the power is given to liquidator to provide all those support to them, where the duty is given to the liquidator. Will it not be overdoing? Suppose the liquidator says that write a letter to the department or any the government department that what is right, what is wrong, and who will bear it? Liquidator is only a representative and court officer. He can't justify action of the CD when it was in operating. Today he can't justify, he can't give any, it's supposed to be done by the management. That means the assessment supposed to take place only when management is in place, not after management is thrown away. Anyway, I leave it to you all that. I wanted to show you because this particular position, literally I wanted to, few avoid transaction, we have to be very careful, which I wanted to tell you. Then after that, I will take you through some case laws, or I will take some case law, then I will do. In assessment, yeah, I will take you to few matters, whatever the matters which this only I was sharing. This only I was saying recently in the matter of employee provident fund. This is it. Recently, Honorable Enclerk Principal Bench Chairman held. This only I was saying that any claim which arises, okay, as per the statutory scheme under claim under is subsequent to the liquidation commencement, Ajay did not commit any error in not accepting the claim. That means there cannot be any fresh claim arising out of any of the action taken after liquidation commencement. This has been confirmed by Honorable Enclerk in, Employee Provident Fund Organization, Mrs. Nazik, Mrs. Grish. And also another thing is the recent judgment. This is June 30th, June 2025, wherein against GST and Central Excise, it very clearly said that adjudicating authority did not commit any error in rejecting IA, where appellant cannot be held to be a secured creditor of CD, and the appellant also cannot claim any penalty with the payment of statement date. If you see the judgment here, they made it very clear. The chairman made it very clear. I'm saying diluting the powers of rainbow paper, I'm saying. See, this is the honorable chairman of the NCLAT. We have the view that AA did not commit any error in rejecting. The appellant cannot be held to be secured creditor of CDNs. The appellant also cannot claim any parity of the payment of GNG. The judgment of Honorable Supreme Court Rainbow cannot be relied by appellant for the proposition of the dues under Central Excise Act. Okay. That means the Rainbow matter has been considered to be as a ruling, no, or judgment which for that applicable specifically to that case. And on many matters, honorable courts have started taking, and of course it has been confirmed by Supreme Court itself clarified, but still the same thing has been followed by our honorable chairman in. So these things also we can, you can see these judgments and read it when you have, because we have a lot more points in this. The paucity of time, I cannot, I'm not able to take you through. This is the judgment where the Honorable Supreme Court has held that Honorable Supreme Court and whatever held in the Rainbow is confined to the factual circumstances only. That is Section 48 of Gujarat. So therefore, it is restricted only to that. They made it time and again. They made it clear, and we can have many more points in this judgment. Even this employee provident fund judgment. You can leisurely go through if you want. I will share also the judgment copy, or you can take down the name and take it. The reason judgment, what I'm saying.
Sir, can I interrupt you a bit, if you don't mind? 2 minutes. Sir, something related to this. Only thing is, let us say somebody is a secured creditor. It may not be the department. Let us say a financial institution is a secured creditor, but not a secured financial creditor.
Okay.
And so under liquidation waterfall mechanism, as a secured creditor, along with workman, he comes precedence actually compared to all other creditors. Okay. But under section 30 of the code, during the resolution plan, whether as a resolution plan, section 30 talks about financial creditor and operational creditor. Okay. So in the resolution plan, are we supposed to make provision for the secured creditor who is not a secured creditor and who is not an operational creditor? And hence, I need not refer to section 53, waterfall mechanism. What's your view, sir, on this?
No. Actually, no, you are trying to bring it section 53 and section 30.
Yes. It is not a liquidation. This is CARP. During CARP, what is the status of a secured creditor? That is what I'm trying to understand.
32 of the IBC code you are telling.
30. 30
you said. Okay.
30 IBC.
Versus 53 you are telling. Right?
Yes. Versus 53.
That's
because 30. Yes, you are right.
Yeah. So in that, your point is that they are secured creditor, but not a government due.
Not a secured financial creditor.
Okay, financial creditor, basically who lent money, okay?
Who lent money, who has been admitted as a secured creditor, but not a secured financial creditor. For a particular reason, for whatever be the reason, because he has taken mortgage of some of the assets.
Okay, fine, okay.
Yeah, but the funding has not come into the CD, so let us say we have...
Third party, okay, you are selling mortgage for third party mortgage kind of thing.
Third party mortgage thing, so he is only a secured creditor.
Okay.
Now, during the resolution plan, in the resolution plan, can I leave him saying that he is not a financial creditor? Section 53, I need to refer during CARP only when he is a secured financial creditor or an operational creditor. Since he is a secured creditor classified under other creditors category. So I need not make provision.
Okay, so that means...
Take that stand. Yeah.
No, let me understand that properly. 53, what you are saying, the word uses is different, correct?
53 is different, yes.
Yes. Here the language is?
Secured creditor, yes.
You are telling for B, you are telling, class B, you are telling, correct?
Class B, yes.
So first workman debt owed to secured creditor, it says.
Correct.
Payment of such a creditor as relinquished, what is that?
Correct.
So,
first of all, he should have relinquished.
Do that creditor has got a power or authority to relinquish the security?
He is holding a security means he has the authority to relinquish the security.
He have got that. That means he is satisfying the secured creditor.
Correct.
Who have a power to relinquish the security.
Correct.
So where is your concern?
But if we go to section 30, please go back to section 30, sir.
Yeah. Okay, section 30. Okay, that.
Yes, sir. Point A talks about the subclause A talks about insolvency process cost. Subclause B talks about operational creditor, where it says that he shall be not less than amount to be paid to such creditor in the event of liquidation under section 53. Or the next clause says if the amount distributed under the resolution plan had been distributed in accordance with section 53. So that is fine. Okay. Whichever is higher. Then next line says provides for the payment of debts of financial creditors. This financial creditor is very important, who do not vote in favor of the resolution, for basically dissenting financial creditors in such manner as may be specified by the board, which shall not be less than the amount to be paid to such creditor in accordance with section 53 in the event of liquidation of the thing. So these two, below this is there's nothing else talking about any creditor. Now, if I look at this, it says payment of financial creditor. Okay. This man is not a financial creditor, he is only a secured creditor. So in my view, I feel, during the resolution plan, I need not make a provision for this because I need not refer the liquidation waterfall section 53 because he is not a financial creditor.
See,
company, yes.
Okay, you finish, you can finish. Okay.
Yeah, so if I go to if the company goes into liquidation, CD goes into liquidation, naturally he gets priority as per section 53. This is what I was thinking, sir.
Okay, ma'am. It's okay. My understanding, I'll tell you. Then probably we will deliberate and find come on the common page. We'll come in the same page. Let me understand this, then I can try to be in the same page. See, what I would suggest, what I understand, there the word used is secured creditor.
Correct.
So secured creditor means person who secured. Secured is nothing but who created a mortgage by virtue of Companies Act. Okay, you know that the mortgage has to be created one person to become a secured. I think you must be accepting that because the language of secured creditor is very clear. Okay, so that means the charge has to be created in favor of a person for him to become a secured creditor.
Yes.
Correct. This you are not.
Yes.
Okay. Now, see, let's try to understand independently what the law. See, leave it all this thing. What I understand here, the word financial creditor, what it is used here in B.
Yes, sir.
This only you said, na?
Yes. Yes.
See, what I understand, there can be financial creditors who are not secured.
Correct. That is one. Yes. Unsecured financial creditors.
That's all. Who is that? Who may be that category? There can be a financial creditor who is not secured. Who makes that category?
All this, it may be ARC, it may be some, what is that called? What financial?
I'll tell you. Home buyers may come.
Home buyers or unsecured financial creditors, ARCs.
Correct, no?
Yeah.
Home buyers may come. So those who are not holding charge or mortgage.
Yes.
Yeah, but they lent money. Now it evolved. The law got evolved to the level home buyer also is to be considered as a financial creditor. So we are considering them as a creditor. But basically, the definition of financial creditor is the time value of money. Who lent money is considered as a financial creditor. That need not to be secured, may be unsecured or secured.
Correct.
But there in 53, it uses the word of secured creditor. So what I understand from this here, which is wide. Financial creditor is wide. Secured creditor is restricted.
Correct.
Secured creditor is a person, because home buyers are not secured creditors. Even you see after this landmark judgment, okay, even now home buyers are not considered as a secured creditor. They are considered as a financial creditor.
Correct.
Though they mortgage the land to some other banker, and they would have taken money and they would have given to the CD, correct?
Yes,
By giving the property only, they are taking money from another bank and giving to the CD.
Yes.
Correct? But still, our law has not got evolved to the level that to treat or consider the home buyer as a secured creditor. Still, our law treats them as a financial creditor only. So, my understanding is that the financial creditor should be understood in wider terminology than secured creditor. Rather, I should say, see, all secured creditor will be the financial creditor. All financial creditor will not be secured creditor.
Yes, sir.
Is it okay?
Sorry, please repeat, sir.
all financial creditors need not, okay, I'll put it this way. All secured creditors are financial creditor.
No, sir.
Okay, tell me. Exception you tell me.
Because I have a person who has given finance not to this CD but to somebody else, but he is holding the asset of this CD. And there is a Supreme Court judgment in the case of JP Infra in 2020, where it says if the person has given money to somebody, it has not gone into the CD. He is a secured creditor. He is not a secured financial creditor, and hence he cannot come into the COC. There is a Supreme Court judgment.
Okay.
So he is a secured creditor. I agree. He is holding the assets. I agree.
Okay.
Under waterfall mechanism, along with workers, he gets priority compared to any other creditor. I agree.
Okay.
However, if you say whether he is a financial creditor, my answer is no. He is not a financial creditor. Financial creditor is a person who has given finance to the CD, not to somebody else, and calls himself as a financial creditor.
Okay, whether you are trying to find a solution in CRP stage or liquidation stage?
Sir, this is in CARP. I am facing this problem right now.
Not in the liquidation stage.
Not the liquidation. This is CARP stage, where the question is whether we need to, because the money is scarce. Actually. So during the CARP stage, should I refer to section 53 for a person who is not finding place in section 30 at all? That is the question, sir.
Yeah, correct. See, here it ends stating that provide for payment of debts of financial creditor who do not vote in favor of plan in such manner as may be specified board, which shall not be less than the amount to such creditor in accordance with the 53.
Correct.
What you are trying to say under 53, as a secured creditor, whatever the person who you're calling X is coming under secured creditor under 53, correct?
He is coming under secured creditor. He is
not coming as a financial creditor.
Yes, he is not a financial creditor. He has not been brought into the COC.
You need not to refer to
voting right. He does not have voting right also.
That's what I'm saying, ma'am. What I'm saying, if you are not bringing that X company within the parameter of financial creditor under this provision,
correct,
then you need to refer 53. That's what you are telling, correct?
Yes, yes.
Sir, can I add something on this, sir?
Please.
In one of the cases, I rejected one claim of operational creditor.
Okay.
And subsequently, the operational creditor went to the NCLT bench.
Okay.
And NCLT adjudged that operational creditors as secured creditor on the basis of shares of the corporate debtor which were pledged by the promoters. So, sir, according to you, whether he will fall under the definition of financial creditor? Because he subsequently did not get any claim priority because he was not a financial creditor in liquidation.
See, what I'm saying here, he has lent money. He has not lent money.
He has not lent money.
So how he became a creditor to the CD?
Sir, that is actually NCLT bench.
What kind of transaction I'm saying? Transaction. What kind of transaction? 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 What kind of transaction
operation. He was an operational creditor, sir.
No, that's what kind of transaction I'm asking. Operation creditor.
Buying of goods. Buying of goods.
Buying of goods. So it's a operation creditor only. Basically,
Operational creditor.
Basically OC only, correct?
But that promoter had pledged shares of the corporate debtor to him. And on that basis, he was adjudged as secured creditor by NCLT.
By NCLT?
Yes.
So there's no charge created?
There is no charge created. And that order we cannot challenge, sir. So if I were to challenge that order, I would have to go to NCLT. But I said no, let him become the secured creditor. But then nothing was owed to him because the value of the security was 0. So I explained him and he got convinced.
Okay. See, there are a number of orders are coming. Okay.
Yes.
Out of that number of orders, number of questions are coming out. There is no answer. Okay.
Absolutely right.
In that, your question also is one of that. Okay.
Yes.
If you see, if you read many orders, there are many questions are coming out. Okay. But there is no answer at all to that. Like that, here, first of all, I don't understand the logic behind it. With the due respect to the orders given by adjudicating authority, but still, by giving a share as a pledge to a trader is considered as a security creditor, I wonder. Then he will be in the equal footing to the bank who is holding the property of the company as a security creditor.
Correct.
Is that the intention?
I don't know what was the intention, because in my case, what happened, the order was reserved. And subsequently, we learned when the order was passed, at that time we could not challenge it. We did not get the opportunity to challenge it.
I don't have time, otherwise I can explain more on this.
Yes, sir.
Not leaving the order. NCLT, I'm not interpreting NCLT order, okay? Yes. Let it be law. I'm not going to interpret that. But I'm just going to subject only, okay? See, in Companies Act, if you see 1956 Act and 2013 Act, okay, the pledge was not considered as a charge.
Okay.
Okay. If you just pledge shares, you can't create a charge. And okay, under 123 of earlier Act, and even now under the new version of Companies Act. Why? What is the reason about it? What is the reason? What is the reason? You just tell me, what is the reason why pledge was not charge was not created? Why statute was not, or why the lawmakers was not giving that luxury privilege to the pledge?
So the charge may be created, but it is still not registered.
No. Charge itself is not created. That only I'm saying.
Okay.
Because when you register, only charge is created, actually speaking.
Okay.
Sir, pledging is physical document is handed over. Charge is where is registered and created charge in MCA and all that.
That's what. Now see, now got evolved. I'm just saying, what was the original intention? Why initially the charge was not considered for the purpose of charge creation? Means pledge was not considered for the purpose of charge. Means in pledge you are handing over the possession of the title. Title means charge.
Yes, it is movable property.
Correct.
It is always of the movable property.
That is one. Okay, that is one reason. Reason two is that share value is not constant like a property value. Okay, the property value will go up. Okay, there won't be a diminution in the property value like a share value, because that's why there used to be a standard clause in a pledge agreement. Generally, you can go through any pledge agreement. There will be a standard clause in the pledge agreement saying that if you if you pledge shares for say 10 crores rupees, the share value goes down in case to 8 crores. The agreement will provide to compensate 2 crores by the promoter or the pledger by the pledger.
Correct, sir.
You understand?
Yes.
The reason being, the value is not constant there. So I really fail to understand whether they can really given that privilege of security creditor, because value cannot be maintained. Value can go down even to 0. That won't happen in a case of immovable property mortgage or charge. Okay, this is the reason earlier why the act was not really recognizing pledge to create a charge or as a secured. I'm saying pledge as a secured. Okay, because it is a physical handing over. It is a movable. It's a physical handing over. So anyway, I think this is the exception what you got. Let us not take exception as an example.
Yeah, sir, at the same time, we have to go back to this financial creditor and secured creditor. Sorry, my humble request.
Yeah, tell me. See, now what you are saying here, so you want answer for that.
Yes. I'm looking for your views.
No, very simple. What I understand here, you are telling secured creditor as per 53 is not a financial creditor under section 30 of IBC.
Correct.
Right. Still, do you have to provide for him in the plan?
Yes.
In some written opinion, you wanted me to give my view in the session. So, see, my view is not going to be the end to this. Okay.
That's okay. I want to understand, like my loud thinking, your loud thinking, I'm looking for.
Okay. See, what I'm saying here, see, if you can be able to argue and win, okay. But for sure, there is going to be one case that will be filed by you. Okay. I'll tell you practically. You leave out all the interpretation and all. I know how the IBC came in 2016, now 17. Then now it got evolved. I'm seeing all this now. Okay. So I'm just telling. We are seeing every day in, day out. We are seeing all drama. What is happening in the IBC? Correct. By stakeholders, I'm saying promoters or anybody for this matter to take advantage of IBC. I'm saying only the liquidator and RP only is fighting against them not to take advantage of it. Correct? Undue advantage of it by outsiders. In fact, as one of the 4 pillars, as IBBA said, it is only RP and liquidator only is fighting to make sure that the stakeholders or outside people are not taking undue advantage of IBC provision. Correct? Like that, what you are saying, see, I accept your view, no doubt at all. But it will hold water in front of the court, I don't know.
Because in the Supreme Court ruling, what I was referring to, the Supreme Court very clearly, it has mentioned very clearly that you are a secured creditor, I agree, but you are not a secured financial creditor. Your intention is different from the financial creditor's intention. Your aim is to recover the money, his aim is revival.
Madam, I'll tell you what exactly the court would have understood or what would have thought of. Idea is that financial creditor is nothing but money, time value of money. You've given your money to someone and instead of you are keeping it at value, you're given to somebody else and you are to earn for it in terms of interest for the time value of the money. Okay. Because you lent the money. That's why the status of financial creditor is given to someone who lent money. Okay.
Lent money to the CD. Lent money to the CD.
Here, somebody has given us a third party mortgage. He only gives the property. Yes. Correct? He is not giving a money. Yes. He is not given a money. Where there will be a time value of money is not involved at all there.
He has given money to somebody, not to the CD.
That's what, not to the CD. That's why I'm saying. There is no time value of money involved at all to CD.
Correct.
That's why the court has considered him as not a financial creditor, I'm saying.
Yes.
Only security creditor. Because, even Companies Act itself is permits that you can mortgage your property or create a security and pay commissions for the person who is giving a security. Just you can pay a commission. That's why you can see the language. There's a concept called commission in the Companies Act. Commission is nothing but if the person, if they is giving us a third party mortgage, the law permits to company to give a commission to him. So here commission, that means he is transacting as a business.
Sir, as a follow-up of this, see, let us say I am not providing for him because he is a secured creditor, not a secured financial creditor. But he is holding the mortgage of the property. Now, if the resolution plan is approved, can I get the release of the property in the ROC, I mean the registered office?
You have a big faith.
Because adjudicating authority has approved my resolution plan?
You have a big fight, madam. Don't worry.
Okay.
See, when everything is clear itself, the things are before the court and getting fought for years together. When things are very clear in the court.
Okay. Okay.
We are sitting in a scenario in a legal world when act is clear and provision is clear.
Yeah.
Our liquidator, our friends, our RP friends, liquidator friends are before the court for so many years, including me. Okay.
Okay.
When the provisions are very clear.
Yeah.
What I can say on your situation. Okay. So
okay,
I told you very clearly, your ex company will not release the mortgage. Okay.
Yeah.
Not release. When you pay money, so what will happen? He will file all kind of cases. There will be a case before the NCLT, there will be a case before civil court. Because recovery is there. No. It's also falls under Transfer of Property Act. Okay. Because mortgage. That jurisdiction comes under Transfer of Property Act. He will file a civil suit also. Parallel. Okay. Because you can't say all this moratorium there, all that you can't say. He will find a way out for that also. Okay. So what I'm saying, conscious call only you have to take.
Okay, understood.
Okay. So that's why I told you that my view is not going to be end in IBC. Other things are okay. IBC I said. Okay.
Sure. Thank you very much.
I'll take you to important case which I am in the beginning I told you that I will take. Now these are very important case which I thought I could share to you. With lot of difficulty, all this gathered against our government authority friends. So this is the cases, okay, in the matter of claim which is filed by department conveniently with lot of delay. Okay. I think our friends can make use of all these cases which I'm going to share here. Okay. Conveniently, the departments are filing cases delay. I mean, claims delay with the liquidator. And they know that anyway they can go and file appeal before the condemnation before the adjudicating authority. And also they conveniently they will file appeal under section 42. Irrespective of 5 years is over, 6 years is over, doesn't matter. They will file and they will fight the case. Okay. Conveniently they will do that. But at least as a liquidator, as a RP, we should have certain verdicts in our favor so that it will be useful to us. So these are the things which I thought that will be useful to you. When any department, this is income tax I collated, but any department, they are giving a claim, they are filing a claim with the liquidator delay. See here, if you see under Supreme Court, Honorable Supreme Court in ISPAT, they made it very clear that code will override anything inconsistent, including Income Tax Act. And nobody bothers, no department bothers about it. Okay. They are telling, no, we are Income Tax Authority. In fact, one of our friends said income tax is asking to file income tax return. Is it not? Who is that participant, sir? Some income tax department is asking you to file return, no? You are there?
Yes, it was me, sir.
Can I take your good name, sir?
My name is Jagdish Ahuja, sir. I'm from Mumbai.
Okay, no problem. See, now you see, sir, return they want to file income tax department, correct?
Right.
When your liquidation is commenced?
Liquidation commenced on 9th March 2021.
9th March 2021. Okay. Because why I asked this now, sir? There was an amendment brought under the Income Tax Act, including who can verify the return. Okay.
Okay.
That amendment has been brought in Finance Act 2018.
Okay.
They added the word IRP, RP during CRP can verify.
Okay.
Can verify the return. Okay, you can go through the Finance Act.
Okay.
No, I am giving the points to your case actually. Okay.
Yes,
2018 Finance Act, there's an amendment made in the Income Tax Act whereby the provisions, exactly I couldn't recall the section, section 20 or regulation 20. Okay. There was an amendment made 140. 140. There was an amendment made in section 140 who can verify the return under Income Tax Act. Okay.
Okay.
The Finance Act Amendment brought and inserted the word language IRP and RP during CRP.
Okay.
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 After that, cleverly, an amendment has been introduced in the rule by Income Tax Department. Income Tax Department in October 2021.
Okay.
October 2021, by way of an amendment to the rule, enabling power which is given under Section 140 of the Income Tax Act, using that enabling power, as may be prescribed, they used the word 140.
Right.
As may be prescribed. Okay.
Okay. Okay.
In that, they brought an amendment in the rule, whereby Rule 20, I believe, whereby they brought liquidator also into the verification of return. Means who can verify the return, liquidator also can verify the return. It is not compulsory. It is that liquidator is given a power to verify.
Okay.
Please understand that. That's
right.
why from the beginning of the session I'm deliberating on the difference between the power and duty. Power is different and duty is different. The amendment to Section 140 of Income Tax Act has given the power to the RP and IRP and RP during CRP that they can verify for the purpose of filing. They are not given duty to verify.
Got it, sir.
Okay. Same way, unfortunately, our Income Tax Department friends, they amended the rule 20 and they included the word liquidator.
Okay.
Here, very important to understand, overriding and through backdoor entry, why they are including liquidator, we don't understand, because income tax itself never understand the liquidation properly. I'm saying, because liquidation is a kind of an ocean. Someone has to understand, means someone has to deal with that, then only they can understand. Okay, they simply thought, what is there? Let us include liquidator also. But Principal Act 140 is not giving that power to income tax to include. You understand what I'm saying?
Yes,
Principal Act only says IRP, RP during CRP word is used. But rule amended in October 2021 to including liquidator, which is completely ultra virus.
Got it. Yes, yes.
So you can argue the matter saying that first of all, the provision itself is ultra virus. Correct?
Right.
Because the very section 140 of income tax only says during CRP, because during CRP only CD is going concern. The
Correct.
RP,
Good point.
yeah, RP and IRP stepping into the shoes of management and running the company.
Running the company. Correct.
Yeah, that's the idea why they brought 140 amendment. But these people, without understanding anything, without understanding any logic, simply wherever possible add liquidator. But IBC where it provides for, IBC doesn't provide. You show me where it provides for filing of return. Where it's provided. Where it's provided, sir. I showed you section 35.
No, I understood, sir, your point.
Yeah, where it provides. We are not given that power at all. Why everybody should unnecessarily jump onto the liquidator? That you should do this, you should do that. Otherwise, you have power. No, you amend the IBC code. Give power to liquidator, give duty to liquidator.
Correct.
You are not touching IBC code at all, because you have to answer big parliament legislators. You have to answer the legislator. So you don't want to touch the IBC code. Then you have to answer because see, they don't answer. They want to implement law.
In my case, what happened was, I met the income tax commissioner also. But for different assessment years, the matter is with different commissioners. And they are separately writing to me, and I have to explain to each and everyone. So this is an harassment, sir, happening to me.
That's why I'm saying, sir. See, difficulty means these are the difficulties, sir.
Correct.
See, you want to tie my hand as liquidator. My hand is not visible. You want to tie my hand. Correct?
Yes.
But you want me to, you are giving a duty of playing volleyball. How could? Then you find fault also on me that you are not playing volleyball properly. You give my powers and duty in the law, in code. Law, I mean code. Okay. Right. Now I'll tell you this. This is not my view. I'm drawing this view from here. See, everyone must be knowing this. Okay, but still I wanted to show this because here in this case, the Honorable Enclart went up and said very clearly, because you said no return filing. Here, that order is stated here. Please see the order. This is gone on appeal, but it is pending before Supreme Court. Still, Honorable Supreme Court dismisses the matter or pass order otherwise. This holds good. Correct? Do you agree?
Yes.
So today the law as on date is this. What is before us in Om Prakash Agarwal versus S. Kumar. In that what it says, it is clear that when company is wound up under order of the court, the return shall be verified under 178 of IT Act. IT 178 is not at all applicable to IBC. Please note. Okay?
Correct.
It is excluded. Or you all must be knowing that. So during CARP under some all this. The return shall be verified by insolvency professional adjudicating authority. All this is recorded. But after recording this, Honorable Enclart went on to say, however, there is no such a provision in the IT Act. That's why these people have jumped and amended.
Correct.
Through backdoor entry, they brought liquidator name in contravention to the provision of Section 140 of the Income Tax Act. That they don't have a power to include the liquidator at all. Okay. After seeing this order, probably they would have taken a call to do that. Okay. However, there is no such a provision in the Income Tax Act, code, and regulation. That liquidator of the company under the code is required to file income tax return. That means technically, Honorable Enclart said liquidator is not duty bound to do this. Filing the return. For filing the return, the financial statement was required to be annexed. Yes. This 139, it makes it clear in the company Income Tax Act that the return should accompany a financial statement balance sheet. But liquidator does not have a power to draw a balance sheet. Then how he can file? Unless you attach the financial statement with the income tax return, the provision 141, I believe, okay, of Income Tax Act, it says it is a defective return.
Correct.
It becomes a defective return. Then why this Income Tax Department wanted unnecessary income troubling in liquidator? You file the return after the very much the provision there in the Income Tax Act, when it does not have attachment of financial statement balance sheet, it becomes a defective return. Then what is the use? Then they want to force liquidator to file defective return. So this is the position, legal position. For filing a return of financial statement is required to be annexed, does not assign. See, for filing a return, the financial statement is required to be annexed. But these are the language wording of Honorable Enclart. But the code IBB liquidation process regulation does not assign a duty on the liquidator to prepare a financial statement. Chapter 3 of regulation provides power of function of liquidator as follows. Shall submit report, asset memorandum, progress report, sales report, minutes, final report. And along with that, section 35, what I showed you, that's a duty which is given in addition to that. That doesn't say that you have to file returns. Okay. So now, liquidator shall preserve these are the powers is given. That's what the Honorable Enclart has concluded. Says that these are the things he has to maintain. So saying this, Honorable Enclart concluded in that case that we are of the view that liquidator of a company liquidity is not required to file income tax return. Is it okay?
Yes, sir.
So this is before the Honorable Supreme Court, not disposed. So unless this ruling is not accepted by Supreme Court, this becomes a ruling till the ruling comes from Honorable Supreme Court.
As on date, this prevails.
Yes, supposed to be. If any development is, our friends can update me. To my knowledge, it is pending for Supreme Court.
Thank you so much, sir. This is really very helpful.
Okay. These people unnecessarily troubling liquidator, every government department without reading the provision properly, without understanding how it should be read and understood, unnecessarily troubling liquidator and filing cases and cases, making them to stand before the court and answer to court. All this is waste of time to the liquidator only. Then how the cases can be completed in 1 year? That's why it is taking 7 years, 8 years. So these are the matters. See, I'll do one thing. I think, see, these are the case laws. It's a very important thing. I thought I should bring it to you. I'll share all this to to Madam, Anjali Madam. You can take copies of all this.
Yes. Thank you so much.
This will be useful to represent before the government or court. I collated all this for that purpose. Okay. So this is the another order. Everywhere it says very clearly. These people, they keep their eye blind department. They don't want to read anything and understand anything which stops them. They want to read and understand which gives power to them. If they stop, they will keep their eye blind. Yeah, any department for this matter. Unless they get heavily from the court, they will not stop. They have to get heavily from the court. Then what is this? Why this so much order is passed? Then why unnecessarily liquidator and RPs are troubled to do this, that? Where is the power, first of all, to liquidator to do that? See how many cases I have for TDS deduction. And whatever the court has ruled, all this is in favor of the liquidator. See, another file I show you this. Here for the delayed filing of claim delayed. There are so many judgments are there that a claim should not be filed a delay with submitted delay with a delay to the liquidator. So much case laws are there. I don't know why the eyes are going blind and the people are fighting before the court years together, which is already there. Already it is there before us. See, it gives the impression to me as if we are using the mirror to see some hurt in the palm. It is happening that way. That's why it is taking years together to finish any liquidation. Because we want the mirror only to see hurt in the palm. We are not directly seeing it. We don't want to see it. See, these are the cases. Very clearly it is said. So the claim has to be reference to the liquidation commencement date. That means the claim supposed to be on liquidation commencement date. It is very clear. How could conveniently claim can be filed any time after assessment, any time after they decide whenever they want to. Suddenly they wake up, they immediately, anyway, one fellow liquidator is there. Nobody bothers the world. And he can be taken for a ride. Give claim, let us take him before the court and fight the case before the court for years together. And years together, giving disregard to the liquidator. Finally, liquidator will take all the meetings. Okay? See, how many cases are there that return should not be given? In fact, to your surprise, I'll show you one income tax appellate tribunal case itself. There is an appellate tribunal of income tax in 2021 recently. They held that respondent could only initiate reassessment duties. They cannot transfer boundary, initiate recovery proceeding under 33(5). Their own tribunal stopping them from doing the assessment. Then why they are troubling a lot liquidators like you and me? I really fail to understand. Because their own tribunal has said there's a boundary, there's a this thing is given, protection is given. Assessment should not be simply done. This is not an honorable NCLAT. This is honorable income tax appellate, their own appellate tribunal. Who else has to say for them to stop troubling liquidator? See? There is no shadow of any doubt that when the corporate debtor goes in either the CRP or liquidation, taxing authority can stake their claim of tax due either before the settlement period, but within the time limit only, it says. Not after that. In the same order, I'm saying. See? In the same order. They themselves are saying that you follow the time limit. Who bothers? Nobody bothers. Simply file a case. Simply file appeal under section 42 of IBC. Years together, run, take time. Do whatever drama you want to do before the court. The government is doing drama. What to do? We are here for everything. Here, same way for GST refund also. Refund also they will not give. They'll keep on fighting against liquidator. There's so many cases which says it has to be given. Refund has to be given. They keep their eye blind. Their eye turned blind. They will simply file a case. No, we will not give. You have to go and fight years together to get. Which is already, the law is already there in front of us. But no government department wants to see this. See, I collated purposefully for this purpose. So that you all can make use of it. Good. In fact, I wanted to run my PPT. I don't have time. So really speaking, in fact, I prepared avoidance transaction about 74 pages. I don't have time. So then we have to sit whole night only if I have to run this entire PPT file.
Sir, still, sir, share with us.
I'll share the PPT. No, I have another PPT also I wanted to run through. See, I don't want to kill the time by running the PPT. That's why I didn't run the PPT. Otherwise, I would have taken to PPT. I wanted to practically decide. See, here also I prepared about 75 pages. Entire rules and laws on the same powers. All that anyway I covered in the act itself. I showed you all that, whatever the defaults, everything I covered. Anyway, I'll share all this PPT to you. You can leisurely go through and. But what we have discussed is more important than simply going through the PPT. That's how I understood. Okay. Any doubts you can ask me. Yes. We are only talking about difficulties. Please, if anything, any more difficulty, please ask me. If I know, I will tell you. So that means liquidator is faced only with these difficulties more, not any other difficulty. Anjali madam, if no other questions, can we conclude, ma'am? I'll share all these inputs to you. You can please share to participants. Anjali madam, can we conclude? Madam is not there. Till madam comes, at least we can deliver something. If anything is there, you can please tell.
Thank you very much, sir, for such a wonderful session and sharing your experience with us. Sir, please, you are requested to share a presentation.
Sure. Thanks, ma'am.
Thank you so much, sir.
Thank you. Thank you so much, sir. Thank you. Namaskar.
Thank you. Thank you so much.